So I welcome you all to the 17th Medico Legal webinar series of the IMA Maharashtra State. To start the program, I would hand over to Dr. Pankaj Bhandarkar sir, who is the IMA Maharashtra State Secretary. Over to Dr. Pankaj Bhandarkar sir.
Thank you, Dr. Ashok Shukla. I welcome you all. Good afternoon, everybody. I welcome you all on behalf of IMA Maharashtra State. Friends, we have with us our immediate past president of Maharashtra State, Dr. Hoji Kapadia, President Maharashtra Medical Council, Dr. Shiv Kumar Utture, Dr. Santosh Kakade. I welcome them all on behalf of IMA Maharashtra State. Friends, today we have an array of excellent speakers. Dr. Srimati Rajalakshmi Rao, former member of National Consumer Redressal Commission, New Delhi. Dr. Shiv Kumar Utture, President, Maharashtra Medical Council and member of National Medical Commission. Dr. Sanjay Gupte, President, Governing Board, CIILM, Pune. Dr. Ravi Shankar TN, Chairperson, Medical Legal Cell, IMA Headquarters. Dr. Vidya Shetty and Dr. Shilpa Pawar. I welcome all speakers who are going to enlighten us regarding medical legal problems. Welcome you all from IMA Maharashtra State. Friends, this activity of medical legal series is going on for last 4 to 5 months continuously. Thanks to Chairperson Dr. Ashok Shukla, Co-Chairperson Dr. Rajkumar Suryavanshi. Then most of the times Dr. Dinesh Thakre was moderator, convener, always a helping hand for these people, and absolutely very good cooperation and support from Mira Bhinder branch. So I thank Dr. Dwivedi and Dr. Mehra, their president and honorary secretary. I am Mira. I am sure Dr. Shukla will continue this series during the next tenure also, because I think this is the last lecture of the series for these office bearers, as we are having the Mastacon on the 28th. So before wasting time, I think I will request Dr. Avinash Bhondwe, President IMA Maharashtra State, to deliver his presidency like this.
Thank you, Dr. Pankaj, and good afternoon, everybody. This is a very prestigious moment for me because this is one activity which we began this year, and with a continuous and enthusiastic support and by Dr. Ashok Shukla, and he's all the time he's finding new topics and the very eminent speakers, and this has been really one of the major features of this year, and I'm really happy. This being the last webinar on these medical legal aspects for this year, for this IMA year, but I'm sure this won't be last for the medical legal cell webinars or the discussions, and I think this will go on and on and on, and with the tremendous zeal by Dr. Ashok Shukla, by Dr. Dinesh Thakre, and all other the team members, the president, secretary of Mira Bhinder, and of course everybody is rather having a very good response to this and very good opinion about this, and I'm really happy that not only our members from IMA Maharashtra State, many of our stalwarts from all over India are attending these conferences or these webinars, and it's really one of the things which we are really proud about it. So thank you once again, and thank you for all the delegates who have been attending this webinar. I'm sure we'll continue with this similar during next year from the month of December also, and wish you all the best, and thank you very much.
Thank you, sir. Thank you for those kind words and motivating. It was just because of your guidance and always standing with me and guiding me, because of which I was able to execute such a wonderful webinar series. And my co-moderator, Dr. Dinesh Thakre sir, from the first program till now, on every program. He's standing with me, my co-chairperson, Dr. Rajkumar Suryavanshi also. So as you have already, sir, suggested, definitely that was in my mind. It's a very good suggestion that we should start taking some judgments also and cases which have been either judged or maybe some hypothetical court cases which could be occur, so that people understand how the things work and why those judgments come, what were the mistakes done, and how those errors could have been rectified, etc., etc. So I'll definitely consider. So as we are running short of time, I'll directly will go to the first speaker. And today the first speaker is Dr. Shilpa Chetan Pawar. She is an anesthetist and a legally qualified doctor. She is DA, FCPS, LLB, and postgraduate diploma in medical legal system. And she is going to talk on a fantastic topic, which is a very different topic: role of medical evidence in conclusion of the criminal trial. So over to Dr. Shilpa Pawar, madam. You can start.
Good afternoon, respected Bondway sir, respected Bhandarkar sir, Shukla sir, and Dinesh Thakre sir, Kakre sir. I am going to present today on the role of medical evidence in conclusion of criminal trial. I just want to introduce this topic. Medical knowledge is specialized form of knowledge. A layman may not be in a position to have medical knowledge without proper education and training. The knowledge of a medical expert is always essential in the criminal justice system. The expert evidence given by a medical person comes to the help of the court in deciding various matters. Particularly in case of death of a person, medical evidence is inevitable. Such evidence can be obtained through the post-mortem report. The importance of post-mortem report is a tool in the hands of prosecution. It becomes useful to decide the guilt of an accused. The interaction between medicine and the law has played the main role in the recent years. Medical science gives clues to how the death of a person, how the injuries was caused, while the law prosecutes a person for killing and injuring the other. The postmortem report examination of wounds, chemical analysis, the expert reports are admissible in the court as an evidence. The importance of medical evidence at present is in increasing tendency. The medical evidence includes doctor's reports of examination, chemical analysis reports, serologist, DNA test in a trial where injury, death is involved. The cause of death or injury determined as the injury as antemortem or postmortem, probable weapons used, the medicines, poisons, and the effect of consequences of wound, whether they are sufficient to cause the death in the ordinary course. The duration of injuries and the probable time of death. In the same way, while the offense of a trial, kidnapping and rape, medical opinion is added to establish the fact that the girl is minor, whether rape was committed under influence of liquor, medicine, intoxication, or if death is caused by excessive force used by the accused to the minor child, etc. Evidence is not exactly defined in the Evidence Act, but the opinion of an expert from the field of science which covers medicine also is admissible under Section 45 of the Evidence Act. Interestingly, while the Section 45 makes an admissible the opinion of an expert, it doesn't say anything about the weight to be attached or given to the opinion of an expert. In case of medical evidence, it has to be weighed by taking into consideration its corroboration or conflict with oral evidence as case may be. 7 types of evidences are there: individual evidence, class evidence, trace evidence, physical evidence, testimonial evidence, indirect evidence, and circumstantial evidence. This medical evidence, medical experts evidence, it comes in a physical evidence. Characteristics for the admissible evidence are: it must be relevant, it must be material and competent, it must have some reasonable tendency to help prove or disprove the some factors. Offense against the human body, it includes hurt, grievous hurt, homicide, murder, rape, and sexual assault causing the miscarriages. Opinion, it includes also the opinion as to injuries and weapons used during the case. In case of Sudha Renuka versus State of Andhra Pradesh, in Supreme Court 403, the Supreme Court has observed that one of the offense is available, but the failure to do so sometimes causes the it abrupts the course of justice. Medical evidence, it may be direct or opinion evidence. In case of Nagendra Bala Mitra versus Sunil Chandra Roy in Supreme Court case number 706, the Supreme Court has laid down that it is wrong to say that it is only opinion evidence, often direct evidence of the fact for upon the victim's person. Time of death. The time of death, the Supreme Court has observed the evidence of medical person is merely an opinion which corroboration to direct evidence in the case. It has been observed in various cases that where the eyewitness's account is for credible and trustworthy, medical opinion pointing to alternate the possibilities is not acceptable as a conclusion. Duty of a medical officer towards the court. The duty of medical officer is to assist the court to provide the impartial evidence. You are not there as an advocate for or one side to provide the facts as you know them and an occasion of an opinion. Giving evidence in the court, take the oath of affirmation. These are the court procedures. Giving evidence is not like having a conversation with an advocate or judge. Question and answers. If unable to answer, giving evidence is not a memory test. A medical legal report or their notes is written. We have given already to the prosecutor. The 3 pages of evidences are evidence in chief, cross-examination and re-examination. All court procedures we have to go through. Tips for giving the evidence and avoid being argumentative, avoid using humor and sarcasm. When giving your answer, it is good practice to turn to the judgment. Judge, in the event a party objects to you a question, the expert should not stop until the objection has been ruled on by a presiding judge. Here the value of medical evidence is when there is a conflict between oral evidence and subjective evidence. The Supreme Court in the matter of Vijay versus State of Delhi in Supreme Court case number 191 observed that there is no dispute that the value of medical evidence is only corroborative. It provides that the injuries could have been caused in the manner as alleged and nothing more. The use which the defense can make of the medical evidence is to prove that injuries could not possibly have been caused in the manner alleged and thereby discredit the eyewitnesses. Unless, however, the medical evidence in its turn goes so far that it completely rules out all possibilities whatsoever injuries taking place in the manner alleged by eyewitnesses. The testimony of the eyewitnesses cannot be thrown out on the ground of alleged inconsistency between it and the medical evidence. It is also true that the postmortem report by itself is not a substantive piece of evidence, but the evidence of a doctor conducting the postmortem can by no means be ascribed insignificant. The significance of evidence of a doctor lies vice versa in injuries appearing on the body of the deceased person and like use the weapon, and it would be the prosecutor's duty obligation to have corroborative evidences. In case of death declaration, it must be voluntary, truthful, made in conscious state of mind and without any. At the time of taking the dying declaration, the time date of starting of the dying declaration, time of end of the dying declaration, patient is conscious, oriented in well response to oral commands on self, and signature and time of the signature are some important factors which we include in giving the dying declaration.
Thank you, Dr. Shilpa, for a very good presentation where you really showed the importance of the medical evidence while going in the trial. I acknowledge and welcome Dr. Santosh Kakade sir, who is the member State Consumer Forum for our webinar. Also, we acknowledge Vice President of Haryana Medical Council, Dr. Pankaj Munteja sir, welcome. Dr. Shivakumar from Dharwad, Karnataka, we welcome to the webinars. So we'll and also welcome the second speaker has also joined after just finished his surgery and from the operation theatre. Welcome Dr. Sanjay Gupte sir. So I would just like to make some announcement. One is for all the attendees. See, whenever you are joining, there your Zoom link is registered by a name. So a name is displayed in our uh, digital account. Now, if your name doesn't matches, because that is the thing which we are going to send to Maharashtra Medical Council as the attendance. So if the name doesn't matches, though your attendance doesn't get counted. So please see that you rename yourself. Sometimes people are using cell phones. So in our record, it is seen Galaxy 310, but we don't know who this Galaxy is. So when we are sending the account, the MMC will not accept he is Mr. So and so. So I would request everybody to please rename them as their name, so that for the attendance purpose, for getting points, they don't have any issue. As well as I would request people who have joined to be there till the end to be eligible for the Maharashtra Medical Council point, because this gets live recorded and a digital attendance goes to MMC. So people should not say that I had joined, but then I had an emergency and I had to leave and I have not get the point, because we just send the attendance sheet and as per your time you have attended, the Maharashtra Medical Council gives you the point. So we'll go ahead. Normally we ask everybody to put their questions in the Q&A and the speakers to answer if they are able to, or at the end we take all the Q&A so that delays don't happen to other speakers who have also logged in. So we will directly go to the second. Before that, I would like to mention that IMA Maharashtra State is planning, it's already planned and decided to start one of the courses called for specifically for legally qualified doctors. Now, why that need of legally qualified doctor courses came? Because a lot of time that we have our members who are legally qualified also. There are a lot of members. Dr. Dinesh Thakre is legally qualified. Dr. Shilpa Pawar, me myself, there are many members who are legally qualified and they can represent their members, our members also, or whoever they want to represent in the consumer forum. But a lot of time what happens is they don't know the exact way how the consumer forum really practically works. So it was an initiative which was started, which will be officially informed through IMA Maharashtra State once it's through their brochure. But I'm just briefing about the program and then why the need arise and how the program would work. This is around a 16-week program where we'll be having theoretical as well as a moot court sessions. And the special part of this program course would be that it is going to be having faculty, all honorable former judges and member of consumer commissions. So they exactly will be telling us how things go, where and how it has to be represented, why and what mistakes happen. And this program course would be in collaboration with CILM, that is the Core India Institute of Legal Medicine, and the main director is Dr. Sanjay Gupte sir, who has already joined, who is also going to be our next speaker, who is also going to tell about this. So I would request the Dipen to show the second slide of the speaker, Aditya. So I would like to introduce Dr. Sanjay Gupte sir. I think so. He's a renowned person. Most of the people would be. I am a big fan of him. Seeing him as being a gynecologist also, because sir also is a gynecologist. Listening to him when I had not done my law. So Dr. Sanjay Gupte sir at present is also president governing body of CILM Pune. Today is going to speak on a very interesting topic of role of legally qualified doctors defending prudent legally qualified defending prudent doctors and need of training code procedures. I would just give a brief introduction because he has a huge achievements. He was the chairman FIGO Ethics Committee, chairman ICMR. He's ex-chairman of Ethics Committee, Maharashtra Medical Council, received n number of awards. He had a distinction in LLB when he finished in 1994, stood first in his MD Gynac through Pune University. He's published more than 100 national and international papers, contributed to in books. He was past president, past senior vice president Foxy. N number of achievements. Over to Dr. Sanjay Gupte sir. you can share your presentation directly, sir. Yeah, sir. Just I would like to acknowledge Ms. Raj Lakshmi Rao, madam. She is the former National Consumer Forum, madam. She is already joined. Welcome, madam. I acknowledge your presence, madam. Thank you, madam.
Right.
Yeah, Dr. Sanjay Gupta, sir. Sorry.
Thank you.
Yeah.
Yeah, thank you, Dr. Ashok, for those very kind words. I'm no luminary or anything. The need arose in 1991, and then I decided that it's better that we know something about the law and, did my law. Having done that, at that time, the Foxy was in the midst of a lot of problems, many members facing this new law, and that's why we started the medico legal cell, and eventually this medico legal cell went very well and had a lot of work, and it's doing a really great work for all our members. Over a period of time, what was great was, many of our doctors started taking interest in law, and everyone realized that it's important that we know not only our faculty, but we also know a lot of law, and so now a lot of us have become qualified. In spite of that, what happens is that especially when it comes to the codes, and especially when it comes to the consumer codes, initially we were not recognized as representatives in those codes. So there are a lot of people like Dr. Santosh Kakre, Dr. Naurange, everybody took interest and pains to see that the consumer courts recognize us as the actual representatives of our doctors who are in trouble. And now that has started happening in front of Maharashtra Medical Council also, and also in when I was in MCI ethics committee, we realized that the lawyers do come, they raise a lot of technicalities, but the medical expertise definitely lacks as far as they are concerned. But when we discuss with them our issues, then we also realize that there are so many legal technicalities that we need to know to actually represent our client. And that is why, after a lot of thought, this particular course has been brought forward, and where it's a good mix of what we know as doctors and what we do not know, even though we have done law, because we do law in a very theoretical manner. We pass our exams, but there are subtle issues about right from how to answer the notice to what exactly technically what is meant by a written statement, how it is to be presented, and so many small things are there and which we need to look at, and we don't have the wherewithal. What do we do? When to go in appeal? Where to go in appeal? What are the timelines? How to wait for the results? Whether we should be proactive in getting to know what happened in the court. What are our responsibilities? There are many things that we need to know, even though we have done law and even though we have done we have the medical expertise. So there is definitely a need for a course where these two things have to be put together. And who best than the faculty, who themselves are the members of various fora, and they can guide us. And then it will be a great thing for all of our colleagues that they will have their representatives who understand their language, who understand what can happen and go wrong in a particular case, and always will be sympathetic to and understanding on that side also. At the same time, we'll have expertise to present their case in front of the fora in a correct way. The forum members, especially the honorable judges, would appreciate, because it's not just the presenting the case, even the etiquette in the courts is very correct. And many times our representatives, when they go, they feel that they know everything, they are about the they're real medical experts, and sometimes they can really rub the member or a honorable member or a judge in the wrong way, being a little paternalistic and showing that as if they know everything and the judges don't. So, these things can cause a real problem. And that's why we need to learn these subtleties. And that's why it was thought that such a course will be really important, and that we will be able to help our colleagues represent them in the court of law. And again, we have none other than Dr. Mrs. Rajalakshmi Rao today to explain to us all this. She has been a really active member in the past. I've attended so many of her talks and lectures, and she had come out with some wonderful judgments through the national forum. And I think she's the right person. She has written a wonderful book called as Consumer is the King. And I think we should all avail of that book and go through that also. And I think she is the right person to guide us today in this manner. So I'm sure you will invite her later on to talk about this and guide her. And so I implore all our colleagues who are interested, not and done their law, or at least done their PG DMLS courses, that they can represent us in the fora, our colleagues in the fora, and that will go a long way in helping each other. So Dr. Ashok, and
Yeah.
I think the webinars that you are taking out are wonderful. I really appreciate the work that you have been doing, and I'm sure our fraternity is going to be really grateful for the work that you have been doing. So please go ahead, and I think let Dr. Rajalakshmi Rao take over through you.
Thank
Thank
you,
you
Dr.
so much.
Yeah, thank you, Dr. Sanjay Gupte sir, for making understand the members the need of having a properly not only theoretical but practical way to when they represent them in the consumer court for getting the better outcomes. And I definitely feel, sir, a lot of doctors of our IMA are both legally qualified, and they will definitely come ahead and take the advantage of this unique type of course. And specifically when the speakers themselves are from the higher the judiciary and from the consumer forum, I think so the knowledge they are going to get from these courses are going to be immense and of huge benefit for them. And thank you for the webinars, sir. Your line gives a huge motivation, because trying to get the best topics and which are really practically beneficial to our members, so that they in the beginning only try to reduce the amount of error they can by doing a good paperwork and other topics. Thank you, sir. And definitely we will go ahead and looking forward to Rajlakshmi madam. So I would go ahead to the next speaker. So thank you, Dr. Sanjay Gupta sir. So we are very happy that today we have Honorable Ms. Rajlakshmi Rao madam, who's former member, National Consumer Dispute Redressal Commission, New Delhi, and on a topic which already Sanjay Gupta sir told the need why it was, and she's going to tell us about the defending the prudent doctors, why it's important. I'll just give her introduction, which she has done her MBA from Osmania University and MS Advertising from University of Illinois, USA. She served as a full-time member for 10 years in National Consumer Dispute Redressal Commission, Government of India. And already Dr. Gupte sir told that she's written 2 books. One, Consumer is King, and the another is Consumer Rights and You. 2 fantastic books, and I feel all our members should read, because they will understand exactly the consumer movement, what madam had supported. And she's also served as Reserve Bank of India Committee on Customer Service in Banks. She's been member of Film Censor Board and the first lady president of American Alumni Association, Mumbai. She has been the first lady president of American Chamber of Commerce, West Indian region, former advisory member of Insurance Advisory Committee of Insurance Regulatory and Development Authority, that is IRDA, Hyderabad, for 2 terms. So she's founder chairperson of All India Foundation of Deaf Women. She serves as a member advisory board of Council for Fair Business Practices. We are obliged and happy that madam we are have to you as one of the speaker, madam. Please over to Dr. Ms. Rajlakshmi Rao madam for her oration.
Good afternoon, all of you. And I must thank you for your introduction. Of course, I was Indo-American Chamber of Commerce Western Region President about a few years back. Maybe I didn't update myself in the website. I've become the first national president of Indo-American Chamber of Commerce.
Congratulations.
Yeah.
Thanks.
52 years, they've never had a woman. So I have always been going into this, unknown paths, kind of a thing. And consumer courts is also one of those. I don't know why, I'm just inclined to go in those, areas which I've never treaded before, nor did I have education or an experience, nothing, zero. It's just that my heart felt when I came back from US with all these MS in advertising and MBA. And I said, I'd have been number one in advertising. But I just didn't feel right to do unfair trade practices and misleading advertisements. Because you do have to say certain things, which is, which is the way it works. I said, not in India, and not at that time when I came back some years back. I said, I can't make a life and money out of something where an ordinary man who's just earning little money will see the newspaper and not know it's an advertisement, and they will buy that product because we wrote some beautiful stories there. I said, I can't make my career out of this in India at that time. Today, it's okay. I'm talking about then. That is my start. So that's how I came to consumer courts without any law degree. District forum in Mumbai, in a shed, small shed somewhere near Nariman Point barracks. But it was just like a small space. It's like that is a court, that is a eating room, that is a retiring room, everything that only for all the 3 people, and some toilet somewhere very far off. We have to take a charge and go. It was really in a pathetic stage, and we were paid some $100 a day we attended or something like that. But I have to tell you this because that is the beginning of my career in this. That was my happiness. I was so happy doing justice to a common man who has no other recourse. I said, oh my God, his insurance, this woman, her insurance for a cow or something else, or whatever. And they just don't have any doors opening for them. They're just too poor or too illiterate, or they have no idea. And I can't tell you, I worked for about 3 years, I think, there, in the district forum. Then I was elevated to the State Commissioner of Maharashtra. And those were my happiest days, because to feel that you're able to do something with your mind and your heart in place, and to put those judgments in a manner where it may not be exactly strictly under law, but it will do the justice. So to do that, you have to work much more than even the lawyers, because you have to find a way out of this. Because previous judgments completely bind you. And how to write any judgment? For everything, the lawyer will say, Your Honor, this is the judgment the Supreme Court has given, something is given, so you can't think differently. So we have all these judgments in our favor, insurance especially, like that. And for everything, they would always poo-poo your thinking. And I realized I have to devise a way of doing the right thing. What is important is not go by what is right. It'll go up and everybody will be okay with it when it goes to an appeal. That should not be your attitude. Your attitude should be that you are doing the right thing. Let them go against it, doesn't matter. At least put it in paper, put your thinking. So anyway, that's my thinking. Maybe because I was not a lawyer, I think that helped me to think differently, out of box thinking. Always my questions were out of box, and all the lawyers would be very upset because they were never prepared for these questions. Maybe my studies in US to think differently, whatever. I thought differently from everybody else. I know that, the bench or even in front of me. That is my background. I'm explaining to you where I'm coming from, so that when I'm saying the other things, you will see my mind and my heart and my thinking. I want to share that. The point I'm here is to share how I thought, and this is how people will also think somewhat in those similar lines. You have to be prepared. And then I went to, and of course, Maharashtra State Commission had a full support of judges always. They always believed I was doing the right thing, and I would convince them this should be the one, especially in medical cases. Nobody wanted to write medical cases, those judgments, because first of all, it's like a huge file fully dusted. Nobody wanted to even touch it, this God, this whole big, huge file is your property, please take it. Because I'm a little emotionally connected to people and their feelings, and I would argue for whatever. So the bench always, whether it's State Commission in Delhi also, they would always be very happy that I write the judgments or I decide that. I mean, they would always consult me on that. But yeah, that's how it was. But the turning point came in Delhi. I was thinking about a particular case, and I know justice is not being done on the record of what I'm seeing to the patient who has come. And I was just thinking what to do. As I said, lawyers always tell that the other cases are decided in this matter. You cannot go against it. Supreme Court has decided. It will go to appeal and it will be squashed, my judgment. They would just put that fear. I was never there for a job or any fear, I just doing for the love of helping humanity and our country. That was my only thing. So then I was just very perturbed, how, because not only I write it, but my bench has to also sign. That's another problem. Otherwise, it's a dissent order. They can write a dissent order. So I've always wanted, I didn't want anybody to dissent mine, at least on the bench. I don't mind an appeal. They can always remand it back or go against it. That's okay. Each bench can think differently. But the bench I'm sitting on, at least they should be convinced in what I'm saying. So I would go to the chamber. I will normally we never announce it on the bench. So I will go to the chamber. I'll explain to them. I will speak for whichever the person is, whether doctor or the patient. Whatever I thought was right, I would discuss with them, threadbare, as though I'm their lawyer, whoever it is. And so that there's no dissent, we would all unanimously agree. Then, anyway, it will go to Supreme Court. So I just met some Supreme Court judges in one of their functions or somewhere. So they were always curious in Delhi to see me because I just don't look like anybody coming from their fraternity to start with. And secondly, everybody used to laugh about me that this lady comes in, it's a big joke because some high court judges were from Delhi on the bench. So everybody knew my background, that they would come to Delhi on Monday morning flight, 6 o'clock flight leke aati hai, Friday sham ko chale jati hai Bombay. Every week she goes back home at her own cost. This is a joke, like, they all wondered why, they could see that I'm working from my heart. Because at those days we were paid just about 10,000 per month in Delhi also, in the National Commission also. It was hardly enough to maintain a life. So, but it was the love of my life, so I was just doing. So one judge, they all just generally say, "How are you, Mrs. Rao? What is happening?" And I said, "I'm just having sleepless nights because any judgment I write, it will come to you, and you will simply throw it back on my face. And so, how to write?" He says, "What's the problem?" I said, "Because, there are always opinions coming from Supreme Court to different decisions, more or less, both ways, and more, in the same manner. And I want to go against it, but, I have to write it in a manner where it should stick. I don't want it to just take some more years, sitting in Supreme Court and languishing." So then that one judge said, Supreme Court judge said, "Rajalakshmi, if you think your heart says justice has to be done to this particular person, you write it the way you believe, exactly. And put whatever you want to say in the way you believe from your heart. Don't worry about lawyers and judges and their style of writing or their style of saying or quoting. It matters, of course. We all have to look into all that. But you just put in such a manner, it will touch anybody's heart when they read it. So we can always make an exception we can't actually make a law on that. We can't lay law on that particular one case also. We can always make an exception in the circumstances of this case and make such an exception to your judgment. We can always do that. So don't be worried, because we are here to see justice is done. Consumer court, because that is my point. Consumer courts are supposed to be amenable to consumers to be able to reach out. Ordinary man should be able to reach out. It is that kind of a court. It is not a typical court, where it's completely legalistic and blind law. It's not that. It is a benevolent act So that benevolence has to be seen by the bench. So he said that. I think that was the turning point in my life. There was no going back after that. I just wrote whatever I believed. I quoted all the judgments, Supreme Court, both sides and all, and then I would refer and say what I felt. I think that was my happiest day, and I mean, that's it. So now I want to tell you, because I'm so happy that your organization is starting. I mean, starting this lawyers who've done law, doctors can come and argue for a doctor there. I think it's a great idea because, whenever we used to have doctors come and they want to argue personally, oh my God, they would be so emotional. They would say all kinds of things. They'll just go like bit by bit, bit by bit. They will not go by how it should be argued. They just, as just now Dr. Gupta had mentioned very rightly, I'm not saying manners, court manners. I'm not talking about, yeah, maybe court manners, but just the way of thinking and a line of thinking, they don't understand. They will just go from their point of view as a doctor. They put themselves in that particular position and speak about it. You have to speak in a manner holistically, and that is something. It is lawyers know. Only good lawyers know. Good lawyers know when the bench is with them. Their point is being understood, and they're enjoying the points this lawyer is putting in front. So beautifully articulating the points. We're only looking at the points. And they also, good lawyers also know when the bench is asking certain questions repeatedly, that they're not happy with that particular argument, or they're so disinterested because the lawyer is not giving up that one line of argument, continuously hammering, that the judges are getting headache. I mean, they have to understand bench also reads the case and comes. We know everything. So, but we give that option because maybe we are wrong. So we expect, lawyers to actually open our mind and heart so we think differently. Whereas these lawyers will go on the same track. They won't change the track just because they are prepared like that. So the moment they come to the point and they have to look at the judges and see their body language, it's very important. See the body language and see, are judges with me? Is it going in their mind? Are they thinking? Otherwise, that point is closed. So that is the time you as a lawyer or a defending person should just immediately turn to the next point. Your Honor, it's okay. I think we will go back to this point another time, but let me go to another argument. Just shift that argument to another one. I can't tell you how appreciative I would be if somebody does that. Because, I'm done with this. I've understood. I don't want to hear anymore. So you have to understand, that's what I'm saying, the body language of the bench you have to also see. And then go to the next point. And then maybe next point might be more relevant. Judges are accepting that point better than what you have actually, whatever you have started with. So that's one way. So these are certain, subtle stuff, which I'm telling you. Because you're going to represent. And another thing, I mean, I've got a lot of, actually sat and read all the cases, latest and everything. I thought I'll talk about the cases actually. But I think much more important is to actually let you know the psyche of the bench. That is very important. What I thought, what generally people think, on the benches normally is something you have to understand. And now you also have to deal mostly with the district forum. And because now the jurisdiction has changed. It's earlier, most of the cases were coming to National Commission, Maximum State Commission, National Commission. Medical cases are now we're going to be coming mostly to district forum because of the the act amended. So you will have to deal with the district forum members and bench. I'm not saying they're not good or anything, but it's just that it's a lot more work. And I don't know if they're all across the country are ready with all this, the how to handle these cases in a very good manner. So all the more you have to be very, very careful, because that is the very first court where you're appearing, and whatever you have actually argued almost becomes a finality. You can later on ask for something, extensions and changes and whatever additional information, but somehow the first one sticks. On that basis, you can change. That same thing can be looked differently, but bringing in new evidence later on will be difficult. So you'll have to be very, very prepared with your thing. Don't think it's okay, it's a bench, is a simple bench we can handle. No, it doesn't work like that. You have to be very careful in getting all your information. And more important is, you know, very recently also I've seen some judgments, National Commission and Supreme Court. You know, they have actually sent the case to AIMS. They've asked AIMS to create a board and they should give an opinion. And ideally it should be, it should be followed. But when we saw the case papers and saw their decision or recommendation, we were quite surprised. Not only in my time sometimes, and even now the National Commission did not go by the decision given by the board. And the same with Supreme Court. They also said, we have seen it, we don't agree to what AIMS has said. I mean, imagine most the premier institute in the country and their top doctors have come as a advisory on this particular one and gave a decision, but both the Commission and Supreme Court didn't agree with it. Which means what does it say to you? You know, so that is what I'm trying to say. You know, you have to be very careful while you're defending these cases. It should not be that, you know, in order to do a bit of a favor to your fraternity, you just jump over the other side and somewhere let go of your ethics, you know, thinking it doesn't make such a difference. You know, don't think like that. You know, put yourself in the shoes of the person who's affected and who has a grievance, who lost somebody, you know, who really felt very sad to have, you know, come to you or to your friend. And if you had also gone, what would be your fate? How would you react to this? So you don't be very sure that you know, the decision of some premier institute will be looked into and you can win the case. It's not necessary. Very recently, I've seen Indu Malhotra, Supreme Court judge, has given, and a very similar case had decided long back in it's a case against Tamil Nadu government. And in that, child was born, you know, premature, and they didn't bother to. The weight was very less, as you all know. Retinopathy, ROP is a must. The check is a must, and depending on the weight and everything. And do you know, at that time itself, I'm talking about some years back when I was writing this particular order, and they never bothered, and they just kept on thinking why the child is looking strange here, there, and all. You know, and then finally, by the time they've understood, they came to Bombay. I mean, they went to Dr. Natarajan. I mean, later on, I know Dr. Natarajan, but at that time, I read about him. And he also said they should have actually done this immediately. They should have done in the first few weeks itself. They must check on this, which they did not. And so this, and the child, you know, like right now also, similar case, which has come to Supreme Court again from National Commission. And so I'm just saying, I mean, why would anybody actually support something like this? Why would you support something which is wrong? I mean, ideally, in a case where you have done a wrong, your hospital has done wrong, then it is important that you tell them to set it out of the court. You please accept it. You know, I humbly request. Don't fall into this whole thing. Ho jayega. Isme ho jayega, usme ho jayega. You know, I mean, the biggest case right in the beginning when I wrote the judgment, everybody was horrified. I get 25 lakhs and for a person who has had malaria, and you know, the sister became a doctor later on, and they argued, and they said she had malaria, and they gave a blood transfusion at one of the top hospitals in Delhi. I'm not naming. And the topmost lawyers had come, and they all argued. Actually, it was so difficult. All the affidavits were in their favor, nothing, you know, in favor of this girl. And I could see that, you know, normal person going and coming out with this HIV and all these other things. She contracted that, and they said no, she must have got it somewhere, and she has not even gone anywhere. She's gone home and come back to you. How can you say this? And I knew, there's something, I just could not find a single document. I must have seen files and files and files. Finally, one day it dawned on me that I looked at each of those little blood transfusion that the cases, the case papers. Case papers always somehow give the truth. And somewhere in the case papers, it showed it was, because they said we don't have names of the people who gave it, when they gave it, nothing we have, all that. I'm talking some years back. Now it's different. It's all computerized, I think. And but at that time, and when I went through that, then I saw this particular blood was given. It was actually expired long back, and that it was already infected and must be sitting somewhere, and they just gave. And just by that one little small little thing, somewhere I found the truth. That's what I'm saying. We'll get caught with somebody like me will be looking at that particular thing. And 2-3 months I sat on that files thinking about it, how to resolve this. Because I knew we have to do something to this girl because she definitely got it in the hospital. There's no way she could have got it elsewhere. Simple family, simple. From hospital. So mother said, I will give my blood. They said, no, we have blood. That's another thing. I will give, similar. But they said no, and they gave it. So I gave those days, it was 25 lakhs was a lot. I'm talking about like nearly 20 years back, 18 years. 20. So everybody said, oh, it's going to go to the Supreme Court and you will lose this case. I mean, first of all, my bench also doesn't easily sign all these. They also have to be convinced. Anyway, they did sign. And they went to Supreme Court. I think Justice Rumapal or somebody came too. She saw my order. She said, first pay 5 lakhs, irrespective of the decision of the outcome of our decision. First pay to that. Because they're simple people, even to manage also is difficult. So they just gave that. I was quite surprised, that they just gave it on the very first. I said, we will not admit this. And then after 2-3 months, the hospital and the lawyers realized that what National Commission gave us 25 was very big amount then. And, if the Supreme Court can make it into 1 crore, once they agree with this. So it's better to withdraw. They actually withdrew. So I'm just giving you an example. These are all just examples to make you understand how, how you're going to tread your way. It's actually, we need people like you only in the court to be able to explain correctly, because when these actual lawyers come, they have no idea what they're talking. Actually, every medical case, I had to read a lot of other books, and I used to call US and other countries to all my relatives, cousins and all, without giving any names, and to those specialists, this is the case, these are the general details, and I'm planning to go on this, and these are the issues. What do you think? I actually used to consult and then only close my judgment, even if I've decided. I would never just go because my mind said so. I would always consult somebody who has no idea what we are talking about. And this is the case, this is the case, this case, I find this is the thing, but do you think it's okay? Because at the end of it, I was always concerned, some lawyer somewhere will make a point, and somewhere some good doctor gets hit by our judgment. I never wanted to hurt anybody wrongly because of my lack of knowledge, my not having worked on the judgment. So I was very particular. I mean, I would never write anything against a doctor. Never. The question never arose. Because, doctors are doing great work. I have a lot of respect for them. We are talking about the chun-chun case, some cases where things are like, they've actually done wrong. And Supreme Court even said that they've even manipulated the records, the hospital. I mean, they're saying themselves, even we find it. When we're going through, we find the records are always manipulated. And the Supreme Court actually, I think Indian Medical Council only, they're saying, that within 72 hours, you're supposed to get the records. We actually went on hammering this in all our judgments when we were sitting on the bench. And finally, that's the government has given, it was notified also. Within 72 hours, you have to give the record of the patient when they ask you, at the nominal cost of some printing or something. But the recent case, it took them 6 months. That too, after they were not getting from the hospital. Then they wrote to the medical council And then the medical council asked them to give hospital. Then they gave, it took them 6 months more. And thereafter, also they fudged the records and gave. And that's not right. It was all, they were all caught on this, right? Now tell me, what is your reputation once you're caught like this? So when you're doing all this, do something ethical. Do it. You have to argue. I think bench will be the happiest having you argue. I think it's a great initiative by you all. I truly appreciate. I fully support it. I'm just giving you the other side of what bench may do or may think, you know. So you have to know that. You don't be overconfident. I know it, and just don't start from there. You know, there was one case, I'm just telling you, somebody who had a heart issue, and one premier hospital in Mumbai only. And he was, the surgery was done, he was okay, he was coming back like the next day after. And the previous night, he was unwell, he was just falling, he was not able to walk well, and he collapsed once in the toilet and all. So the family kept on coming to nursing care and all. We are supposed to go back tomorrow in a day, and he's so weak, how to take him? Please talk to the doctor. They kept saying, doctor is busy, doctor is busy. Somehow doctor could not come and see them. Then the day that person actually died, they all came to the doctor's clinic or wherever in the hospital only, knocking on the door. And the doctor didn't have time. He had like so many patients, I mean, who were, you know, there. And so they didn't, but anyway, the person died. My thing was only this. It's not like, I mean, we have to die. Sometimes every surgery need not be, you know, agreeable to you. Your system may not agree to certain things, and, you know, it can go, it's beyond doctor's help also. My point is not that. My point is, what stopped the doctor in calling the nursing staff in the hospital? They're knocking on my door, and they're all full of fear about their family member. You know, they've come so many times to me. So just at least assistant can check on that. What is the point? What are the, you know, the parameters right now, ECG or whatever? Karke bata do. That one little thing they didn't do. They just took it for granted. It's okay, and the person died. And just saying. So it is just that you know, you're all doing great work, but what will help all the doctors? Lawyers will, of course, go by whatever the doctors have done. They have to support it in whichever way. Wrong cases, don't unnecessarily go ahead with the confidence that you can win just because you got a case. Don't ever do that. If you think there was a negligence on face of it, you know, try and tell them to somehow compromise. Just don't go and fight that unnecessarily, because it brings your repute down, and it's got somewhere. But the point is, when you are actually fighting for a particular client, ensure that the client gives you the entire information as a lawyer, because you need to know everything. It should not be a surprise for you. You know, doctor should be very, very honest with you and tell you, this is what I've done, this is what has happened. Maybe there is something wrong, but at that time I did not think. So all the Bolam test and everywhere in Jacob, so many cases, I don't want to discuss because it's not exactly lawyers here, mostly doctors only. So all the cases we decided, negligence is not because somebody died or something, but someone who has like something like diabetes, you don't check his sugar, and you go ahead and do a surgery. I'm just talking about some things like that, which is like for a common man also, it's a known thing. The things like that you can't do wrong, right? You can't be negligent to that point. But what will help you? Forget about anything else. And today's time, it always was my case to tell everybody this, but in today's time, even more. Everything you do, document it. Just put it in your computer, just document it. And everything, history, you just take all the history and put it down. Make sure the patient gives the entire history. Many times we dismiss the complaints of whoever came because they have hidden history. They have not told the doctor. How can a doctor actually take care of you? You don't tell that you had already done certain things, you know, like 10 years back, 5 years back, for some, you know, whatever you had, There are pretty big ailments. You should mention this to doctor. If you are going for a surgery or a big treatment, you have to tell, fully disclose. Many people don't disclose. Patients don't disclose only. Out of habit, not disclosure, not that they want to hide also. Maybe they want to hide, I don't know. But they don't tell. They don't tell the whole history. It is for you and your nurse or whoever is your assistant have to hammer them to give them, because this mindset is not there to give the entire history. They have to give history. You have to write that history. You have to make sure your assistant writes that history. That is always helpful for everything, whether it's insurance or medical negligence. In the history, everything is there. If they don't tell you history and there's something happens later, it is their negligence, complainant's negligence, not yours. But it is for you also to note it down and to make sure you have taken written consent of the person always, no matter what. You tell, I've explained everything and this is the written consent. I'm okay with this. Many times, they look like family members and, I mean, there was somebody who went in Delhi and got her surgery done, and the mother was there, and the girl was not married. The woman was not a girl. Woman was not married, and the mother was there, and so mother said, yeah, Nikalo ovaries and all that, whatever Nikaldo, because all this she has so many medical issues. So they took mother's consent. They didn't take the actual person's. Although in principle they were all friends, they were all doctors, all of them friends. Huge case they filed. And of course, there was no negligence in this. Nothing wrong, nothing went wrong with it. It's just that they didn't take the consent. So on that, Supreme Court has come on to it, saying they agreed. I wrote the judgment, there was no negligence of the doctor at all. But, the Supreme Court said, yes, there's no negligence. But because they did not take with the written consent, so they put such an amount of fine or anything on that person, and something like that. So now written consent is very, very important. In principle, I felt whatever their arguments were okay, and it is like family and all that. Family or no family, when it comes to it, in the court of law, all family breaks up and they fight against each other. So you will have to be very, very careful in getting a proper written consent. And another thing is, in your surgeries, when you're doing, you and a lawyer must make sure, if you're a lawyer, you must make sure that the operation and all the notes, surgery procedures, what was given, the entire thing, put everything documented. Everything documented. Many times, something has gone wrong, somebody died. We see the whole thing. Very meticulously, the doctor has put everything correctly. He did not fudge anything. I'm not joking. Our heart goes to the doctor more than the person who died, because the doctor has done everything possible in his capacity, in his mind, what he thought was right at that time. There are 2-3 ways of handling a case. So, different doctors think differently. Looking back, I can tell 2,000 things, but at that moment, that I thought that was the right thing to do. Looking back, maybe tomorrow some other doctor may say, aisa nahi karna tha. They're always the same case, Everybody finds some other opinion. That's okay. But at that time, when I'm writing the judgment, this was my mind. I thought this was the truth. Like then the doctor, when he's writing, doing some surgery, he thought that was the right thing. So he has done it. Please meticulously, methodically put everything on paper. So it is one of the ways of doing it in the textbooks. May not be the best way. That's okay. That is for a decision and a judgmental. It can be debated till tomorrow. But at least at that time, he put his mind to it and did the same correct way. So that will be appreciated by the bench. So don't ever hide these papers. If they say, oh, nahi dikhao, no. The moment you've done it, everything properly, and explain why you still did it the way you did it. In the circumstances of this case, this person had temperature or something else didn't look right. So I did this particular method. You can always argue the matter in your favor. But if you don't, for not giving records and also not bringing, and the hospitals are now, there's a case from Savita Agar, those days only Supreme Court decided, which made it easier for us. Many times we used to always send the notices to the doctors and to the hospital. None of the doctors would come for years and years and years. And the cases were just like, we don't know what to do when the doctors don't come. What do? You tell the hospital, you bring the doctor. They say, we don't know. They left the job and they went away. They damn well know where the people are. They always know. But they would never let us know. Now, the Supreme Court said in this particular case, Savita Gar case, they said it is not for the complainant to run around to find where those doctors and nurses have gone. It is for the hospital to find out who they are and bring them to make sure that they at least explain why. And then they are responsible. In case they don't do anything, they can't bring the doctors and nurses, whoever have treated in that particular case, then hospital will be vicariously be responsible for it. Supreme Court is very clear on this. So when you're protecting anything, keep these things in mind. Because you may think as a case, it may look very good. But when you really start, when the case starts developing, I can't tell you how many doors open. You would have never thought those doors open. Suddenly some windows open, some doors open, some new thing comes up. I mean, something else happens. So from nowhere, the judgment turns to another angle, which you would have never thought of. But what will always be helpful to you is your record. You keep your record. Don't be afraid of your record. Many times they don't show record thinking that will go against them. We will, even if we find it negligent, at least we will put the thing much less. If it is like, we will not go to crores. We will just put that was just, whatever, little bit we might do in case. But don't ever shy away from giving the medical record to the bench. And honestly, I had no idea of what you're all expecting. I mean, I have a lot of cases I can discuss with you, but I don't know, that can be boring. I would like your president to tell me what is the angle I should speak. I had no idea what was expected from you, but I was just giving general knowledge to most of you.
Definitely, madam, you can take few cases, and it's a fantastic way. Already you have told the holistic approach, how things are. We should be very transparent and open when we are talking, and if something has happened, it happened, and sometimes indefensible, you should not. So it's fantastic talk, madam. I think so. You can take one or two cases.
Okay, I'll just talk about one or two some cases. I mean, simple case, it's just a tonsillitis, tonsils ka. So somebody became brain dead. The doctors and whatever, the hospital said, no, whoever is the doctor, we don't know. They just came and went away. Anesthesia, we don't know. They've come and gone away. They didn't keep any record at all. Nothing they produced. Years and years, it came to the National Commission appeal, and it came to me only. I said, no, nothing has been filed. What is this? How can you say that there's no negligence? How can a young child, 14-year-old person become brain dead? Ye kaise ho sakta hai? At least you show us what went wrong. No, nothing is available. Then there's one thing called res ipsa loquitur, means facts speak for themselves. So you can't save yourselves when you don't show the documents. Facts speak for themselves. So on that ground, we went ahead and we gave a decision, and even Supreme Court could not touch it, because on facts of the case, the person has become brain dead. So then the highest case that you might have heard is a few years back, Dr. Kunal Saha, his wife Anuradha, she died she had 10 toxic epidermal necrolysis. It's a dermatological disorder of an unknown cause according to medical books. And so he came from US and brought her, and they went to many hospitals, many tests and many things. Finally, she died. And so she got 1.55 crore. I'm talking about 10 years back. And I mean, she died, of course, her husband. So it was a very big case because, itna jada kabhi kiya hi nahi hai. And thereafter, now the cases are going to 1 crore and that kind of thing. It's not like, like before. I mean, there was one case where somebody had a hysterectomy, a young lady, some 40, 45 types, absolutely normal, and one of the top hospitals she went to, and to the best of doctors. And so they have done this hysterectomy doing that, what is that called? Laser technology, removing it. And while doing that, she has punctured, and blood started avulsing into the stomach and into that area, and it became a serious case. So they had to call another doctor and quickly open the abdomen and try to see, if they can find where this has happened. And they couldn't find from where this blood was leaking. And then the kidney was getting affected. So her one kidney had to be given up because of this. So absolutely a normal person in our country, how many people are having hysterectomies done? Roadside mein itne sare doctors are doing. You go to the best of the doctors, and you come out with one kidney less and almost died. So, I mean, the point is, everything, nothing is perfect. I mean, you're not gods, something can happen. I'm not saying it's not possible, it happens. The point is, they have not taken the proper written consent and explained to that lady. Only on that basis we could go. Otherwise, we could have always said 1% may in the world it is there, it happens. You always can go into that 1% chances. Isme ho sakta hai. But then what helped that the patient is that the written consent was not taken. That she was doing this type of procedure on her, and that consent was not there. So on that consent, that case itself was settled, and in Supreme Court also it went off like that. So that became a very big, important thing, that written consent is very important. So always in all your things, while you are being a doctor or you being a lawyer, make sure written consent is there. If it is not there on the facts of the case, you have a great case also, you will lose it because the written consent is not there. It's not a small thing. It is something you have to be very, very, very careful about. All of us think it's okay, family, some friend only. Never think. At that time, no friend, no family. Everything will be factually looked at and what is wrong. And also another thing I feel, maybe today is different, but it's always feel, how can anybody file a case against a doctor? Doctors are doing such good work, and pura din raat kaam karte hain. Aadhi raat ko bhi you call, they somehow give you medicines and they look after you. They come and rescue you, and they do so much good work. Why file cases against them? I mean, marna to sabko hai abhi. That person is 80-year-old, 70-year-old, and some young person maybe, but somebody a little older and gaya. So I used to feel it's okay, doctors done their best. I used to think like that at the beginning like that. Why are they filing this case and fighting tooth and nail? The fighting tooth and nail. Case bhi itna nahi hai, to bhi fir bhi they come and spend so much money and fight. Then I understood the psyche. The psyche is not them. The psyche is coming from you. What happens? You did your best actually. You're also upset that person died. Nobody wants anyone to die in their hands. No doctor wants it. No doctor wants to let anybody die just like that. It's not possible. So, I mean, doctors are good human beings. Why will they do that? That's their life to save, I know that. I believe that in principle. The reason why they're coming, when something untoward happens, and they're all looking at a shock and looking at the doctor. At that time, you take the 10 minutes, explain to them, however bad it is. You don't want to face it, I know. It's awful. It's better you actually face it and tell them, I tried my best, but somehow her or his blood pressure went down. I did everything. Anesthetist was there. We tried to do everything possible, and it just didn't work. Something, her whatever body, some disorder, something didn't help me to save her. I tried my best. I did this. Kuch to bolo. Why they're upset? Because they say doctor just walked away. Sorry, and he walked away. They feel very small. I gave all my trust and my money, everything, and put my family in your hands. You are the God. Trusted you, and I just stood outside. You said don't meet for 10 days. Also, I didn't meet. I said I stayed outside. Things like that. I did everything you have asked me to do, the family. and you didn't even think you should at least speak to me for 5 minutes of your time and tell कि ऐसा हुआ, I'm sorry and I tried my best. कुछ तो बोलो, something went wrong, एक कुछ ऐसा कुछ तो बोलो. At least in principle, make them feel they come because of their angry. मैं दिखाऊंगा. They're upset, emotionally upset. I will teach something because I lost my sister, I lost my somebody, father, anybody, whoever it is. The case is not even strong. कुछ है ही नहीं, evidence ही नहीं है, कुछ भी नहीं है. I mean, something went wrong maybe, but I'm just saying generally sometimes not a great case. Either lawyers are pushing the case or they say don't worry, मैं देखूंगा, मैं देखूंगा. The typical Indian mind, you know, मैं दिखाऊंगा, मैं देखूंगा. The typical thing, we don't like to let go. Just that वो 5 minute के लिए spend the time with them, be with them. That will really make them feel doctor tried their best. I was just talking to someone in Hyderabad, somebody who came out of COVID, 30 of them got infected, and he came out of COVID, was negative, and he was also negative, and he didn't his BP, sugar, everything was fine, and the next day he died. You know, he was about to come home, and he died suddenly after becoming negative. So I spoke to his wife. I said, "What happened? And which hospital? Who did this? कैसे हो सकता है negative होके? How can he die?" Then she said, "I don't think it's fault of the doctor. I'm just saying, just 4-5 days back only he died, 4 days back. It's not the fault of the doctor. They all tried their best. I mean, all of us came out. And in his case, he was also coming out. He was completely normal. But somehow, for some reason of his own system, his oxygen levels were not coming right. It has come from what? Because of doctor relationship with her. You know, I understood immediately. That is what I'm saying. Even the person died, the wife herself is saying it's not doctor's fault. There are a couple of cases also like this in some of the hospitals. See, that's where it makes a difference. So as doctors, remember to do that little bit of hand holding in a time like this, you know, because medical negligence is not all about making money. It becomes like that after some time. वो lawyer बोलता है ऐसा, इसको तो इतना लगा दो, उतना compensation दो, डरा दो उसको, doctor को डरा दो. Doctors, both things, they get into such stress. I used to find that doctors get into so much stress. I feel so bad about it. There's not much case, but they're so stressed out. And I keep telling, you know, don't worry, your case is nothing. You don't have to worry. You just put your record, you'll be fine. I used to sort of say wherever I meet and anywhere, no, don't worry, you know, court will always decide, you know, what is right. I said, that after your doctors, don't ever think like that. If any case has gone against a doctor, believe me, there is really a case in it. You know, never think, barely 10% or 7% maybe we've decided, I don't think even more than, maybe even less, against doctors. You know, itne sare apples mein 5-6 to kharab hota hi hai na. So some doctors somewhere have done some wrong, no? So whenever judgment comes, almost, you know, you try to protect doctors. At least I've always tried. I'm sure everybody on the bench also tried. Doctors. Hospital, not so much, but doctors, yes. But, you know, you have to keep that in mind, that you have to handhold the patient and do your thing. I think I should now stop it so that you can, I don't want to talk about cases. There's cases that you can talk about 50 cases also. That is not, that is a case, you know. So I don't think that is exactly, I'm just talking about, I'm trying to change your mind and make you understand the mindset. That is important.
Thank you, madam, for the excellent talk. You had covered and both the people, legally qualified doctors also, you guided that how things have to be presented in the court, which cases has to be taken, if the things are there, how to be, and also the doctors, that the member of the judiciary or the board are also don't want to unnecessarily punish the doctors. So they are always thinking the doctor sympathetically way, because he is not the God and he cannot do. But mistakes like not taking consent itself, and as you told, so many people are undergoing hysterectomy, and if some patient suddenly has a major then automatically things will be seen that why this patient had. And if the things are properly justified, I don't think so any judiciary member would give any compensation against the doctor. So it was good, madam. I know you have worked for a long time in the National Consumer Forum. Member, 10 years, immense number of cases would be there. But still, in the time constraint, you gave a good approach and helping and guiding the members how to go ahead. So we are grateful to you, madam, for this excellent talk, and hope this will definitely help our members. And we will only pray that less and less number of cases come, because the most important line which you gave at the end was communication. That if the communication is good and the healthy doctor-patient relationship is maintained, I don't think so any patient would really feel that filing a case against a doctor, he will never think also. And once the matter goes to the court, then the lawyer automatically starts pushing. And then the feeling comes that we might get some amount of money, and the patient who has lost a family part thinks at least something I will get, which will be have for the members. And immense amount of stress doctor undergoes, that is already seen, madam. You have kind of covered most of the parts in a very short period. Thank you, madam. Thanks for your wonderful talk. Thank
Thanks.
you. Thank you. Thank you, Honorable.
To have joined you.
Yeah. Now we'll go to the next talk. Now again, a very Maharashtra Medical Council Act, because what is this ethics committee, how it's formed, and why, how they go ahead. Lot of time our members have, and who else? Professor Dr. Shivkumar Utture himself, who's the president of Maharashtra Medical Council, is going to give and deliver this talk. He's member of National Medical Council, member Medical Advisory Council, Executive Committee Maharashtra Medical Council between 2012 to 2017, past president IMA Mumbai branch, past finance secretary IMA Maharashtra State, retired professor of surgery GMC, that is Grand Medical College JJ Hospital, retired honorary surgeon St. George Hospital. At present he is honorary surgeon Fortis Raheja Hospital, honorary surgeon Sushruta Hospital, and has immense number of awards and posts he has hold and deliver n number of talks. He is always there as a senior member also from IMA to help and guide us by delivering talks. We are very happy to have you, sir. Over to Dr. Shivkumar Utture, sir.
Yeah, thank you, Ashok. Yeah, first of all, I think I must congratulate the whole IMA Maharashtra State team, since you have taken up a subject which I think for years I was asking the IMA to take up, because in all our conferences, everybody talks about the clinical aspects, because unfortunately that is where you get your sponsorship from. But for the medical legal aspects, we used to never get a sponsorship. But over the years sitting in MMC, let me tell you that you may be the greatest of clinicians, you may be the greatest of surgeons, but that one case which comes up in any of this forum, may it be the consumer forum or the council, that puts you down by almost 5 to 10 years of your life. So it is high time, I think you should start knowing something about law, and especially knowing about how the cases are heard and what are the steps that the MMC takes whenever it hears these cases. Because what I have found over the years is that many of our doctor colleagues take it so casually whenever there is a case which comes up in the council, and they feel that, oh, not to worry, so and so friend of mine is sitting in that council, and I'm sure that nothing is going to happen over there. But you must remember that council is hearings, judiciary hearings which take place over there, and we go according to whatever is presented in front of us, and not if you are someone's friend or someone's relative or something like that. So I think I'll just, because there is no time, I think we are running out of time, I'll try to be as brief as possible, because this is a huge topic. But I think basics of what you should know as far as what happens in the council once there is a case filed against you. So that is what we will talk about. So what you have to understand is first the definitions of these words, because if you read what is there in the Maharashtra Medical Council Act, it talks about medical misconduct and cases to be heard on the medical misconduct. And many a times, if you see the definition which is given in the medical misconduct, in different books is different. But what I would like to try, point out to you is violation of any of the doctor's duties will come under this misconduct. So it is not restricted to one aspect, or many a times we find the lawyers who come and argue the cases for the doctors saying that this is not misconduct, so it does not come under the jurisdiction of the council. But let me tell you, council has got wide powers, and anything as far as a doctor's duty which is not done properly by the doctors comes under the council. Then of course medical negligence, basically, where the failure of the doctor to provide medical services with the requisite skill and care. Now, when we talk about that, the Bolam's Act, which which is there, comes into play over here. So it doesn't expect, the court does not expect you to be the best in your field whenever you're treating the patient, but definitely you should treat the patient which otherwise majority of average doctors would be treating that patient. So that is what the court generally sees. But anything done less than that comes under the medical negligence. And this can go either to the criminal court or go to the consumer court, or it may come to the council also, or it may go to all the three courts, remember that. And then of course medical malpractice. So that is basically the treatment given was below the degree and skill expected of a competent doctor, and that the negligence proximately caused the injury or death. So when we talk about malpractice, basically there has to be some injury or there has to be a death caused to that patient. It cannot be that the bare possibility of causation will not suffice. That will not come under the malpractice. So this is just in basics, I'm telling you what are the three main things as far as your cases may go to any of them, maybe the criminal court, the civil court, or the in the civil we have the consumer court, and of course the council which comes, that also comes under the civil court. But what you should remember, this last line I think all of you should remember, is that a good working knowledge of the law is a must. So along with your clinical knowledge, I think majority of us, or I think all of us, should know something basics as far as medical law is concerned. Why? I'll tell you. Slowly we are shifting towards what the Western world doctors are experiencing. So more and more cases are going to be filed against doctors in the different fora. So it is high time that, just now you heard Madam Rao saying that, when the doctors came and were sitting there opposite them answering the questions, they were so agitated and so depressed. I think that should not be what is the case. If what you have done is proper to the patient, what you have done is as per the medical norms, there is nothing to get scared of the law. But what you should have been, what is very important is not only what you have done for the patient, but what you have documented that you have done for the patient, which is most important, because you have to understand these cases come up with either the council or the courts or anything after a few years. And only your paperwork and your documents speak for what you have done, not what you say, because then what you say goes against what the patient says. So it is better to document whatever you have said. And down the line, as I tell all my colleagues, that a case filed against any doctor is going to be the norm. Today it is the exception. I have practiced for almost more than almost 35 years as a surgeon, and with God's grace or with my luck that there is no case filed against me. But I don't think the next generation of doctors can ever say that. So it is going to be a norm, and we have to be ready to fight this, or we have to face it. If what we have done is right, nothing is going to happen to us. That is what we have. That is what I would like to tell all my colleagues. So I come to the Maharashtra Medical Council Act. So basically the powers of the Maharashtra Medical Council Act 1965. What are the powers that are given to the council? And this is under the act itself that these powers are there. I will not talk about registration and everything because that is not what my talk is for today. But then you have to understand that it is written in the act that the council can prescribe a code of ethics for regulating the professional conduct of practitioners. And it was in 2002 that the MCI, at that time the MCI, which is now NMC, came out with detailed code of conduct for the medical profession. I think all of you must go through this code of conduct, because I don't think any other profession, the councils have given such details of what you should do and what you should not do. And all of us must read this so that we are ready to face any problems in the future. Then, of course, to reprimand a practitioner or to suspend or remove him from the register or to take such other disciplinary action against him as may, in the opinion of the council, be necessary or expedient. Remember, as medical practitioners, we have struggled a lot to achieve the status that we have achieved today. We have gone through the rigors of, our medical college days, then our postgraduate days, our sleepless nights, compromising on our family, on our own time. And there comes one case against you for which, if you have done any gross mistakes, you are suspended. That means what you have done for the last 30, 40 years comes to naught absolutely. So therefore, you have to be very, very careful in today's era as far as, how you treat a patient and what you document as far as the treatment is concerned. So what does the code of ethics, if you read the whole code of, it's a huge topic by itself, code of ethics. I'm not going to go into the details, but let me just tell you that how vast is the, powers of the council to hear cases. The 8.1 section of the code of ethics says that the instances of offenses and of professional misconduct which are given above, that means, there are 7 sections and every section has got a subsection before this 8th section, which in details tells you of what you should do and what you should not do. But having said all that, it further says that they do not constitute and are not intended to constitute a complete list of the infamous acts which calls for the disciplinary action. That means you can see the discretion, it is left to the discretion of the council to decide which is infamous act and which is not, even if it is not written in the code of ethics. If the council feels that it is infamous, they can go ahead and hear these cases. So the councils in no way precluded from considering and dealing with any other form of professional misconduct which is not written in the above 7 sections of the code of medical conduct. So not only that, it further also says that the code is not violated. Every practitioner should see that this code is not violated in letter or in spirit. Now, when you talk about or in spirit, again, the ambit of the council increases because it may not be written. So we go beyond what is legal also when you talk about letter and spirit. And therefore, the powers of the council are huge. And that is what you should understand. And I'll tell you why I'm insisting on this, because in further slides, I will tell you what happens when you come, or especially when your lawyers come and talk in front of this council, which is absolutely not as per what is given in the act or the law. So let me directly come to the sections in the Maharashtra Medical Council Act which talk about actually hearing or what is wrong or what is misconduct. So what happens when you find that someone is guilty? So there are few points which are given in the act of what punishment you can grant to that particular practitioner. And that can be right from issuing a letter of warning when, luckily for us, we have got graded punishments in the council. So if you find that whatever the doctor has done is not so gross, or it is just, of a very small aspect, then definitely we let go of the doctor by just giving a letter of warning to that doctor that he should not be doing that, which states that what he has done is misconduct, but it is not that gross that there should be punishment. But because it is misconduct, we are issuing a letter of warning. But you should remember that letter of warning is also a punishment, because in law what happens is, if you make the next mistake, what mistake you have done in the past, even if it is a letter of warning only, that compounds your next mistake. So be careful that even a letter of warning, don't think that just because a letter of warning is given, I have not been punished by the council. And then beyond that also, then we can remove the name of that person for a specified period, or we can remove it permanently. That means when we say permanently, and once your name is removed from the registry, remember, as soon as your name is removed from the registry, this is informed to the MCI and all the state councils also. That means you will not be able to practice in any state, anywhere in India. So permanent removal of frame, very, very rarely the council ever does that. As far as I am concerned, I have the knowledge in the past about 7-8 years. I think just around 2 cases we have given permanent, removal, and they have been so gross, and they are basically in the PCPNDT Act, where repeatedly they have made that mistake. In those cases we have removed. Otherwise, I don't think we have permanently removed anybody from the registry. Now, what the Act called, as I have stated in my very first slide, was misconduct. And what does misconduct mean? Number one, if you are convicted in a criminal court, there won't be even a hearing in the council. The very conviction of that is there by the criminal court, that means there is misconduct, and the council is going to punish you for that. Then, of course, any conduct which in the opinion of the council is infamous in relation to the medical profession, particularly under the code of ethics prescribed by the council or the MCI, comes under this act. So again, as I said, it is a wide ambit that has been given to the council by an act, and therefore we can hear a lot of cases which you may feel or your lawyer may feel do not come under the ambit of the council, but definitely there are cases which I have been hearing, and I will give you some examples of those cases in the future slides also. Then, of course, the act continues to say that what are the powers of the council. Remember, the powers of a council is equivalent to that which is vested in a civil code. So we have the same powers which are there in the civil code. And when I say that, I am, these 3 points you should understand. That is, enforcing the attendance of any person and examining him on oath. That means if the council feels that we require to call some experts in the medical field in some particular case, we can always send a summons to them, and they have to compulsorily attend the hearings in the council. So that is a power. So tomorrow, as some of the examples were given, that the hospital says that this doctor was not with us, and this doctor is, we are not responsible for that. Remember, we have also in this council, when the doctors have said that that particular hospitals, the protocol is so and so, we have summoned the CEO of that council, of that hospital also in the council, and put him under the spanner over here in the council for misleading the doctors. We have done that. Compelling the production of documents. So any documents which are there can be called upon by the council, just like how any court calls for it. And it is a compulsion that you have to produce these documents. And therefore I say, whenever there is a medical legal case against you, you should keep these documents right till, and these documents should be buried with you when you die. So these documents can be called upon by any court at any time, and therefore you require to preserve these documents till the end. Because what the act says, that till the completion of that case, these documents should be there with you. But remember, even if that case has been completed in the lower courts, both the parties have got the law allows them to go to a higher court. So you cannot destroy the documents after you have got a judgment in the lower court. So documents have to be of medical legal cases should be permanently kept with you. And then, of course, we can issue commissions for the examination of witnesses. Suppose a witness is there who cannot come to the council, then we can have a commission which goes to that particular witness in his place, and we can take down the details from that witness, which can be used when we come to the final judgment. And all inquiries under this section shall be deemed to be judicial proceedings. That means that once we pass a judgment and the written order is given, it has to be compulsorily followed, just like how a judgment in any court is given, and you have to follow that judgment. Of course, this judgment can be challenged, but you cannot say that I'm not going to follow this judgment. Then, of course, whatever is, that is the bare act which I spoke to you. And in that act, there are some places where they have said as prescribed. That means the rules will tell you exactly how we hear these cases in the council. So when the complaints come to us. These complaints can be of two types. One can be a suo motu complaint, which is taken up by the council itself, or there can be a complainant who complains against the doctor. When we talk about suo motu complaint, we mean that either the council comes to know about this particular problem that this medical practitioner has created is absolutely gross and will not be allowed to carry on practice. We may, as a council, without any complaint against him officially in the council, we may also file the charge sheet against that doctor. Or many a times we get from the government, or we get from the, we get cases which are referred to us from the Human Rights Commission. Those cases also are suo motu taken by the council. That means there is no complainant over there, but the council will definitely like to hear your say as far as what the complaint is against you. And these complaints are basically initially submitted or given to the registrar. They are in the name of the registrar, and the registrar then submits it to the president for further action. One thing you have to understand is any complaint which is anonymous, even if it is in writing, even if it is in a hard copy, is not taken up by the council at all. So every complaint has to be where you identify the complainant. Not only you identify the complainant, but now there is a where you have to also give an undertaking to the council that this complaint has been filed by you. So that has to be there. Along with that only then the council will go ahead and hear this case for you. So procedure for submission of complaint to executive committee. Once it comes to the president, if the president, if he feels that we require to ask for details from the RMP, that is a registered medical practitioner, a registered letter is sent by the registrar to the RMP, and the RMP is supposed to answer to that registrar. Now here I would like to tell all my friends is, as far as this point is concerned, be very, very particular, because how and what you answer to this initial letter will define what will happen to this case in the future. We will come to that as far as the next point is concerned. So remember that whenever this letter is given to you, this is the first letter. The council sends you 2 letters, remember, when a case is heard. And the first letter is asking you to explain when a complaint is there to whatever point-wise or para-wise the complaints are against you. So please be very careful when you answer this. Stick to the point. Remember, you cannot be emotional whenever you write, whenever you give answer. It has to be absolutely in legal format that you are answering this question. You cannot say that I did the best for him and I did that and I did this. And many a times when we find the answers coming, they say that I am a doctor who have been practicing for 30 years. I have got these awards. I have got these many degrees. I have studied over here. The council is not interested in all those things. Council is only interested that this is a complaint against you, and please tell us how you have treated that particular patient. That is all. Then if the president feels that he has got the answers from that RMP, then he refers the case to the executive committee or the ethical committee that we have formed now in the council. Once it goes to the ethical committee and we feel that we require any additional information, we will ask for those additional information, or just on the complaints and the answer given by the medical practitioner. We can do 3 things. One is, if there is no prima facie case, then that file is closed. Second is that if we find, see, as I tell in all my talks, that making a mistake or your patient succumbing is not negligence, but not having taken proper care before that mistake is done and not taking proper care after that mistake is done, that can be negligence. So if we find that the proper care, even if the patient has died or there is some permanent injury to that patient, but the medical practitioner has taken proper care as per what are the norms defined in all our books, then definitely we say that there is nothing wrong that he has done, so we exonerate the medical practitioner. Or if we find that yes, prima facie, there is something wrong in this case, then an inquiry is instituted under rules 66 to 73 that will come in the next slides on what. And that is why I go back to my, the number one aspect, that when you answer to whatever has been sent to you, the first letter that comes to you in a perfect way, maybe the file may be closed prima facie by the council, or you may be exonerated without holding any hearings against you. That is the importance of giving a proper answer to the council. Now, suppose that the council finds that there is something wrong and the council feels that we require to investigate more into this matter, then notice of charges is sent to the registered practitioner by the registrar. Now, this is the second notice that comes to you. Many a times my colleagues ask why we have already got the first letter and we have answered the first letter. Why again the notice of charges has been sent and why we have to again answer it? Remember, the first letter is answering to the complainant's complaint against you, whereas the second letter is the charges which is framed by the council, so it becomes much more important, and you'll have to go into details as far as the second. That means there is some prima facie reason for which the council feels that we require to go into details and we require to hear both the parties, and that is what is given. And there again, we ask you to put in your written statement of defense, which is there. And in this written statement, you are also allowed to put in, if you want to bring in any witnesses, or you want to give any documentations, like, you want to give us some quotes from the books or from the journals of how you have treated, or suppose there is some complication caused. And if the book says, yes, these complications can happen in this type of surgery, all those details or relevant copies you'll have to give to the council along with your written statement. Then, of course, whatever documents are submitted by the complainant, you have a right, and we send all these documents to the registered practitioner along with the notice and statement of allegations. So you know exactly what are the complaints and what documents have been submitted against you as far as those complaints are concerned. Then once you reply to that notice, in that notice you're supposed to say if you are going to completely rely only on the reply and allow the council to go ahead, or you desire to be heard in person by the council. So that is again your right, and that is what you are supposed to mention in this reply. One thing that Maharashtra Medical Council has done, and I think many councils all over India are not doing, is that we allow you to have legal assistance during that inquiry. Now, when I say legal assistance, it not only means that registered lawyer should be there. You can also have your colleague to be there to save you. Now, this is very important because just now, as we said, that when a medical practitioner becomes a legal expert or he passes his law, he understands the case much better and he can put it forward much better than a pure legal person who does not understand the medical nitty-gritties at all. So my request is that if possible, what I have, my experiences in the council of all these years is that try to have some legal luminary who has a medical background to save you. Remember, when the lawyers come to us, they stick to the legal points. They will, try to see how the case can be postponed, how the case can be stopped. And they try to say that, try to bring forward that the council does not have this jurisdiction at all. They'll try all those things which they have been taught to do as far as when they do their law. But that doesn't hold good in the council. You are sitting in front of a team of medical practitioners who understand what you have done as far as the medical practice is concerned, and therefore, if you have a legal person who has a medical background, definitely he can defend you much better than a pure lawyer over there. So the procedure basically what happens is that when the complainant is personally present over there, what do we do? Initially, the registrar reads out whatever the notice of inquiry is. Then the complainant is invited to give his say as far as what the case is, and also produce his evidence in support of whatever. So if he has someone over there who wants to give evidence on his part, or he wants to give any written legal documents, he can do that. Once he finishes his say, then the practitioner is invited to give evidence to save himself. So he is asked to give, and he has to basically stick to what has been alleged by the patient against him. So he gives that. Then he also produces his evidence in support. So he can bring experts in the field of medicine to collaborate with what to say what he has done has been right. That is allowed by the council, but of course you have to take prior permission of the council if you want to bring anybody to support you over there. And once we hear that, and if there has been something extra which has been brought forward by the practitioner, we may allow the complainant once more to refute whatever has been said by you on some new evidence, not on if it is just the old evidence that he has produced. And once that is done, then what we do is we ask both the parties to leave the council office, and all the council members discuss in detail about these cases. And another thing I would like to tell you is about the witnesses. Even we allow the witnesses to come. Again, this is not allowed by many of the councils, but Maharashtra, being a progressive state, allows the witnesses also. And when you bring the witness, first the witness is examined by the party who is producing the witness, and then he is cross-examined by the opposite party, and if required, he is re-examined by the party producing him. If required, that means the adverse party has brought out some other facts which was not brought out by the party in the initial aspect. So here also we follow whatever norms are followed in the court of law or in any civil or criminal case. So this is what happens, and then afterwards the council sits and discusses and decides what to do in that case, and then we put it down in writing as far as a judgment is concerned. When there is no complaint, especially when many a times we find if it's a very old case and no complaint, the complainant is no more alive or they are not traceable, even then the council can go ahead with hearing the cases if they find if prima facie something wrong has been done. Or when a suo motu complaint is taken, then the registrar reads out whatever is the complaint against that particular RMP, and then the RMP is invited to state his case, just like how it is done when the complainant is there. And then what happens is that the powers are there with the president to ask questions, which the president does. And beyond that also, if any other member of the council wants to ask the questions with the permission of the president, they can ask direct questions to the party. Those are the powers of even the other council members who are sitting there in judgment. So once that is over, then of course we let the RMP go out and the case is discussed in details amongst the council members and the judgment is given by the council. Now all these proceedings, just like how it is in the court of law, these proceedings, the records are kept in the council, and the RMP or the complainant can, once the case is closed, can ask for these records. It is their right. Remember, the council also comes under the right to information, so we are bound to give all those details. Beyond that also, section 73 says that if the council, this is what is put up as far as, what the complainant will say, then what the RMP will say. But beyond that, if the council feels that we require to have more details, then we have the right to call for the practitioner again and take another statement for the practitioner or a clarification from the practitioner. That power is there with the council. And once, as I said, the decision is taken by the council, the implementation is there, and this implementation, this judgment can be given directly after the hearing takes place, or it can be sent to the concerned parties. Both the parties get these judgment by registered post of whatever the council is concerned, means either the council has exonerated the RMP or some punishment has been given to the RMP. Now, once the RMP's name, if a punishment is given and he's suspended and is removed, then what happens? Because the RMP should know that suppose he's suspended for say 3 months, what he should do after 3 months. After 3 months that of his punishment period is over, there is a form 19 which that RMP has to fill the form, write in details, and apply again for getting his name registered with the council. Of course, the council keeps his old number intact so that he does not have to change all the details that is there with him. But along with that form 19, what he has to do is he has to give a certificate from any gazetted officer of the state government or from a justice of peace of good character during the period in which he is serving the punishment. That is also a must, because during that 3 months, 6 months, 1 year, whatever period of suspension is there, we require something to say that he is of good character during that period. This is there in the Act in section 77. Then, of course, what happens? Suppose we are either the RMP or the complainant is not happy with the judgments which is given by the council. Then, of course, they have got a right to go to an appellate authority. And today the appellate, first it was the MCI, but today the appellate authority under the National Medical Commission Act 2019 is the Ethics and Medical Registration Board, which has been formed, which is the appellate authority. And those details are also there. You can go on the website of NMC and see all these, what exactly and how to do all these things. But then section 30, what does section 30 say in that? It says that decision, if any of the Ethics and Medical Registration Board, once it gives, it shall be binding on the State Medical Council. That means, if they say that it's just like a lower court and a higher court. The high court can always say that the lower court has erred in giving this judgment, and hence we reverse this judgment. That right is there with the EMR, that is the Ethics and Medical Registration Board, and they can reverse the judgment of the lower court. Now, beyond this also, if any one of the party feels that the EMR board has not given them justice, and as the aggrieved party, they can go further to the actual National Medical Commission against the judgment which is given by the Ethics and Medical Registration Board, but they are supposed to do that within 60 days of communication of the judgment by the EMR board. That means they have got, just like a court of law, they have got multiple fora where they, if they are an aggrieved party as far as the judgment is concerned, they can go ahead and appeal against this judgment. Now, many a times, I've finished how the whole aspect of how the case is heard in the council, and I would just touch upon last 2-3 slides are there of many a times, as I said, when the legal person comes to as your representative over here, many a times they try to postpone us, saying that this case is already going on in a criminal proceeding is going on, and a criminal proceeding of the High Court has a jurisdiction which is higher than the court, which is the council, and therefore we should not be hearing this case till we get a judgment from the criminal court. But there have been n number, I have just given you an example over here, that there is no bar in the law to 2 types of proceedings in a criminal court and a civil court to go on simultaneously in a given matter. This is a settled thing in the law. So I hope, in the future also, when your legal person tells you that, this cannot be heard in the council if it is being heard in the criminal, it is not so. We can go ahead with this. These are the Supreme Court judgment. I've just given you one example over here. And civil court, when I say, it can be the consumer court or it can be the council. The council is also a civil court. Then, of course, many a times they say that 2 civil courts, these cases cannot be heard. Now, that also has been settled in the Supreme Court, where the Supreme Court has said that the jurisdiction of what we hear in the council is basically misconduct or unethical acts that you have done. What punishment we basically give is restricted to the punishment of punishing the RMP. That means we can suspend him or we can give him warning. Whereas a consumer court can give compensation to that person. And hence, the case can go on in both these courts, that is the council and the consumer. And this is also settled as far as the Supreme Court is concerned. Now, the powers of the council is so much that, basically even the High Court has given judgment saying that, what the High Court had done was, the High Court had said that we suspend the license of these doctors till the conclusion of this trial. But then the High Court, when it went into the details in the next hearing, this is very, very important what is written over there in the 7th para. In fact, suspension of the license granted to the applicants by this court would be without jurisdiction. That means the jurisdiction is not even with the High Court to suspend a license. The council gives you a license to practice, and hence the council has the right to take away your license, not even the High Court. And at the end, if you see, the said order of suspension of licenses is modified, and accordingly it is recalled, and the High Court referred this case to the council to take the adequate action against the RMP, depending on how we do the hearing over here. That means only the council has got a right. Why I am insisting on this is, many a times, especially during this COVID period, many of the government entities and departments were writing letters to our doctors saying that we will cancel your licenses. Remember, nobody other than the council has got the right to cancel your registration. Then, of course, beyond that, if we find that what you have done is so gross, because any civil hearing takes time. So even in the council, it may take any time between 3 months, 6 months, 1 year. But we find that what you have done is so gross that we should not allow you to continue your practice. Then there is something called suspend the registration as a holding action. This is not written in the Act nor in the rules and regulations of the Maharashtra Medical Council, but these powers were given by a High Court judgment to us, where we can suspend you till we finish the hearing. And you must remember that the period of suspension naturally would depend upon how gross the allegations are and how gross your offense is. But only by way of this is only by way of an interim measure pending the inquiry. And it is well settled distinction in law between the suspensions which are made as a holding operation. So tomorrow, if we suspend you, but at the end we find that what you have done is not gross, and we let you off with just a warning or something, then this suspension is not held as a punishment. Okay. Only suspensions which are given at the end of when the judgment is given is held as a punishment. So holding, you must remember this, that holding suspension is also a power which has been given to the council. So to end, I would say that ignorance of law does not absolve you from judicial action. So please, at least the basics of law, every doctor should understand, so that he does not leave it to only his lawyer to defend himself, but his valuable inputs, because he's a medical person, can always be there. So thank you very much for your patient hearing, and thank you for the organizers for having allowed me to give this talk.
Thank you, sir, for an excellent detailed presentation. Right from how things go, the whole act, you in a very short period you have given the idea, and about the rights and the powers of the Maharashtra Medical Council also, so that the members understand that it is a quasi-judiciary body. They have to follow all the rules, regulations, and if they don't follow, then the punishment would be very harsh, which can lead to temporary suspension of the license. So thank you, sir. I know you have a meeting to go. Still, you took and gave the whole topic in detail and did justice with the topic. So thank you very much for an excellent elaborate talk, sir. I would also acknowledge presence of Dr. Anil Pachnekar, sir, who's former Vice President IMA HQ National, for his presence, and Dr. Ramakrishna Londe, sir, President-elect IMA Maharashtra State, who is going to take over after the master plan. So I will go to the next topic. Thank you, Uttari, sir. Shivgaru, sir, for the detailed topic. So next talk again is a very important topic. Now, it's something which really is so important that people don't take it seriously, and when they land up in problems, suddenly they realize it was a major mistake they did unknowingly, which they never thought of. And then once the case is there, then they feel this could have been easily avoided, but they never thought of giving that importance. So the next topic is legal implications of visiting consultants. Today the cost of property is immense, running of the hospital is immense. Many consultants are attached to other hospitals and they visit. Sometimes they're attached to more than the amount they can go, say 4 hospitals, 6 hospitals, and they sometimes might do some mistakes. That's the reason this topic is there. And our speaker today is Dr. Ravi Shankar TN. He's IMA National Medical Legal Cell chairperson. He's a forensic expert. He's also a postgraduate diploma in medical legal system. So over to Dr. Ravi Shankar sir.
Thank you and good evening to everybody. I think after 2 tough talks, one by the president of the Maharashtra Medical Council and one by the member of the National Medical Commission, I think it would have taken to you on a very difficult note to practice this profession. They were all talking about the law that has been implemented against the medical profession from the Maharashtra Medical Council. I think a very elaborate talk by Dr. Shivakumar, as usual, the command of the language as well as the command of the law that is existing against us. In fact, we have to say against us and how we have to defend ourselves. And Rao Madam was just trying to go through the whole issue of how much of difficulties we have given to the public. But let us see some of the truth and what not we should do when we are a visiting consultant is what I am going to give a small talk. It's a very quick talk only because the opportunity given for a visiting consultant in a hospital or a clinic is also quite low. It's always surprising how Maharashtra Medical Council and your legal team could try to find topics. This topic, I was trying to steal some slides in the Google, but never had been anybody given a talk or shared those slides in the Google for me to steal the slides. So I have to get some of the slides originally. And it's really astonishing how 200 people can come and sit in the afternoon. Maybe some will put their slides on, screen on and sleep also. But the fact is that they have to be there at least behind the screen. And who is a consultant in a hospital? Income tax rules 194J says someone who does a revenue sharing with the hospital or a clinic that is maintaining him. They say somebody having a minimum guarantee. In a hospital, there are hospitals with engaged consultants. For a minimum guarantee, you are paid a money of 2 lakhs a month and you take care of the cases at a fixed hours. And that's a minimum guarantee consultant. This is where the public comes and says, being pressurized by the corporates to bring in more patients into the ICU and the theater, even if they deserve or not, and make a charges against the medical profession that we are trying to make money and numbers, but which is not the truth. There are senior doctors with a minimum guarantee and there are junior doctors with a minimum guarantee. And the junior doctors are quite often are the medical officers in the hospitals or the RMOs in the hospital. Or who is a visiting consultant and what is its characteristics in a hospital's practice? He is one who has a regular visiting hours in a hospital. A visiting consultant has a regular visit at fixed time. There are 3 different types of visiting consultants. The one who comes regularly is the one which we most of us do practice as a specialist or a super specialist attached to a family hospital or a corporate hospital or whatever it is. There are visiting consultants who are being called infrequently due to the non-availability of one of the specialists in a hospital. Quite often a cardiologist, a neurologist, or an obstetrician who go on a leave during the summer holidays. Not in 2020 where everybody stayed back in their own place of residence because of the pandemic, but this happens quite often during the summer holidays or during the festival holidays, late in the December, sometime during the Puja holidays. Quite often most of the corporates and family-owned hospitals do not have the regular consultants. They have to depend on a visiting consultant who are being channelized through your own regular consultants quite often. and they are infrequently called into the hospital due to the non-availability of the regular consultants. There is a 1/3 type of visiting consultant, the one who is called during crisis, handling a complication. Dr. Ashok Shukla once, when he said about the talk, in fact, he enumerated everything. I just have to elaborate on what he has told me. And this is one place where introspect and see what is the real role of it. It is called once in a blue moon. How many times in a year or in a fortnight the moon becomes blue depends on the hospital and the capable surgeons. Only can be said how often you are crisis managing. Is aware of the hospital, the infrastructure, the availability of the equipments in the hospital. Very importantly, they are sure about the laws and the license that is being existent in the hospital. There are hospitals who might not be doing orthopedic practice, may not have an ultrasound machine, but in an emergency, when you are called for a crisis, they might bring in an ultrasound machine, try to find out something intraoperatively, preoperatively, or whatever it is. These are things that will have to be handled properly. And if we are forced to use these equipments without a license, better not to document it. Though the value of document has already been stressed by our member from the National Commission, Mrs. Rajalakshmi Rao. And another most important thing that the visiting consultant, the regular visiting consultant is aware of its colleagues and their competence. That's a very, very important thing because if you don't write to refer to the right person who is competent enough to handle the complication or crisis, then you too will be called either by the consumer court, to the civil court, the criminal court, or even from the medical council of the respective states. And very important of this visiting consultant is that they need to have to maintain that time. And if they are not able to make it in time, they need to inform it earlier. That's a very important protocol that we have to follow when you are a visiting consultant. A real visiting consultant in a hospital has a freelancer, has got the right to come in, walk out, but then he has to maintain the time what he is. And if he is coming for a specific day and time, he needs to maintain that appropriately. If he doesn't maintain it, neither the hospital is going to give him a patronage or the patients are going to wait in these busy days for him to take care of themselves. And then if you are not specific in your timing and days, the hospital is not going to support you. Your professional commitment towards the patient is quite high. The visiting consultant is always be very, very, very humble to be impressive with the patient, but at the same time, will they definitely have a lesser commitment towards the hospital. The root fact, how many people who are watching this talk, hospital owners, will be aware of a visiting consultant or a lab consultant trying to take away the patient from your hospital to their own practice or to another hospital. And why they take over and why they do it, we'll see it a little later. And these visiting consultants are also eligible to charge the patient. But at the same time, the income tax rule says, even if you are a visiting consultant in a hospital, you need to pay your TDS, tax deduction at source. And that's another very important issue that a visiting consultant will have to maintain in a statutory law in a hospital where he is visiting, or even in a consulting chamber or in a polyclinic. Non-availability calls. These visiting consultants are quite often the anesthetists, OGHians, vascular or a super specialist surgical side, or somebody who does an intervention procedures or take care of patient in the ICU or in a theater. They have the biggest disadvantage of not being aware of the infrastructure of the hospitals. Unless you keep visiting the hospital day in and day out or being known about it, you are not sure about the infrastructure. You might require an equipment to do a procedure, but at the same time, the basics of the equipment may not be available. Advanced attachments of the equipment may not be available at that point of time after introducing the equipment into a patient. And if you are not able to get it, you have to stop the whole procedure, cut a sorry figure both to the patient as well as to the hospital. The hospital will always have a simple word to say, we have a judgment where we will see what it is. The availability of consultants who can support you. You are not sure who is going to follow up the case, to what extent you are going to be there, and what care is going to be provided after you have done the initial procedure or whatever it is. This is a very pathetic situation in the hospital, and the worst is for a crisis consultant. You are not sure why you are called, but then you might get a frantic call from your own colleagues there in that hospital, or your own specialist, or your subordinate specialist trying to come down to the hospital to support a case, either in the theater halfway through or in an ICU almost in the verge of collapsing. Here, the most biggest issue is a concern need to be taken to be involved in the case or to get involved in the operating procedure. And how are you going to explain the concern to the attenders or the patient who is already under anesthesia or lying in the ICU, half alive and half in the grave? This is a very, very important issue. This issue is there mainly because these things can often go to where you need to answer them. What is your scope and whatever it is. The scope of services and liability of you will need to be known. The statutory and laws and license, as told before, you are not sure about it. And quite often the issues is for the obstetricians when there is a labor problem, a urogynecologist where there is a fistula or a rupture ureter or a vascular surgeon in a polytrauma. Somebody does surgery in the abdomen or elsewhere or in the thoracic cage, something is happening on, have ruptured vascular injury happens, then you might need somebody to come in to tide over the crisis. This is the most difficult part of a specialist becoming a crisis consultant. Dr. Shivakumar Utre has told about the Code of Medical Ethics 2002. I think nothing more need to be taken forward if you are sure about the medical ethics. Here are some of the quotes in the Code of Medical Ethics which are useful for a visiting or a crisis consultant or an emergency called a specialist. Particularly 2.5, engagement in this case. When a physician who has been engaged to attend an obstetric case is absent and another is sent for and delivery accomplished, the acting physician is entitled to his professional fees but should secure the patient's consent to resign on the arrival of the physician engaged. In fact, even before he comes into the play, the original attending obstetrician should have to tell their absence and let the next obstetrician to come in, and then only the last part comes in and he has to retrieve and go back to his original act, getting the original obstetrician to come back. First thing will have to be obtained of getting a concern to come and serve the patient as a visiting consultant. Otherwise, the patient has got the choice of quitting the hospital or quitting the clinic and getting over to their own choice of hospital. This is never force yourself as a visiting consultant to any patient. Code of Medical Ethics 4.3, consultant to not to take charge of the case. When a physician has been called for consultation, consultant should normally not take charge of the case, especially on the solicitation of the patient or friends. Very often the patients will say towards the end of the time when they're getting discharged, you seem to me a better doctor, I would like to come over to you for the treatment henceforth in this hospital or whatever it is. I think that's a point of time when we have to clearly follow the Code of Medical Ethics and say, everything you can do it on your own choice and elsewhere in a different place, not in the hospital where you have seen me or whatever it is. The choice of the patient to coming back to you is his choice, but never solicit that patient in the hospital where you are doing a practice as a visiting consultant or an emergency consultant. The consultant should not criticize the referring physician. He or she shall discuss the diagnosis, treatment plan with the referring physician. This is particularly for those crisis consultants or an emergency consultants, because quite often a loose talk at that point of time will always put the hospital into trouble, the primary consultant in trouble, and your name will also going to be added as a third party in the case that is going to come to the consumer court or any other courts. Appointment of substitutes 4.4. Whenever a physician requests another physician to attend his patients during his temporary absence from practice, professional courtesy requests the acceptance of such appointment only when he has a capacity to discharge the additional responsibility along with this or other duties. You might be working in a government setup, do not have the time to come and attend to a doctor. At that point, I think it would be nice if you retreat away from taking the responsibility. Otherwise, you are putting the patient in trouble. Thereby, the physician primarily who has called you to take care of the patient will also be in trouble. And this is where the visiting consultant will have to really work it out whether it is possible to take care. Chewing too much of whatever you can't eat and digest should not be a physician's act. The physician acting under such an appointment should give the utmost consideration to the interest and reputation of an absent physician, and all such patient should be restored to the care of the latter upon his return. Visiting another physician's case, when it becomes a duty of a physician occupying an official position to see and report upon an illness or injury, he should communicate with the physician in attendance so as to give him an option of being present. The medical officer or the physician occupying an official position should avoid remark upon the diagnosis or the treatment that has been adopted. Here I would like to quote one of the Encyclopedia of Medicine, Professor K.V. Trivenkam, under whom I have studied, and we lost him during the COVID. He practiced as a physician till 94 years of age, till the last day when he was admitted in one of the reputed hospitals for COVID. He will never accept a patient coming to his clinic directly. Only a referring general practitioner or a physician or any other consultant can ever send a referring letter to him, and he will go through the letter, examine the patient, write a letter advising the investigation, the line of management, differential diagnosis, and how you can come to a diagnosis based on the investigation. This is the way a visiting physician also will have to do, and all the law, all the code of ethics, if this is really followed by a crisis consultant or an emergency consultant or a regularly attending physician, I think the whole issue of medical legal issues can never happen in between. There are few cases which I would like to quote here. These cases will substantiate the law that has already been existing, or will help you go through this. Very often, the whole issue of the crisis management, crisis consultant comes for obstetricians. The patient consulted a gynecologist with back pain and the lower abdomen and dysmenorrhea. USG revealed a bulky uterus, small fibroid, cyst in the right ovary, hence diagnosed fibroid uterus and pelvic infection was made. Hysterectomy was performed, vaginal hysterectomy, after taking a concern. It was later converted to an abdominal surgery as it was found that the bladder was severely adherent to the uterus. The previous sentence will say pelvic infection was made. At that point of time, trying to choose a vaginal hysterectomy was a wrong choice, probably by the obstetrician, by the gynecologist. The bladder was injured near the trigone. Post-surgery urine output decreased and the patient was diagnosed with a sacrovaginal fistula. It's not a fistula. Fistula cannot happen in 24 hours. It was an injury to the bladder. The patient underwent 2 corrective open surgeries to rectify the urinary bladder injury at another hospital, and the same were performed by a urologist. The defense that was stated by the doctor was that adhesions was quite common in any patient who has a history of pelvic infection, and this causes bladder injury. Sacrovaginal fistula is a known complication of hysterectomy. It was pointed out that as soon as problem developed, the urologist assistant was found and the problem was rectified by open surgery on the next day. Here comes the question mark. The court's finding was that the gynecologist was negligent in conducting the hysterectomy. The evidence of the urologist who performed the corrective surgery on the next day had found that the gynecologist, after injuring the bladder, had sutured it, but urinary leak continued, indicating that she lacked reasonable expertise in performing such corrective surgery. This is the point where a urogynecologist support will always be taken, or a urologist support will be taken. At that point of time, when an urologist comes in as a crisis consultant, his primary aim will be to talk to the attenders that such a thing has happened, that he has come here to do the corrective surgery, take a concern for it, and then get into the paper. This is where I think Dr. Ashok Shukla wanted me to inform visiting consultants who are there in this meeting. The court observed that once a gynecologist recognized that there was a rupture of the urinary bladder, instead of performing the corrective measure, she should have immediately summoned the assistance of a competent surgeon or a neurologist. The court held that the gynecologist is not expected to perform such corrective surgeries of urinary bladder, selected a wrong method and ought to have performed an abdominal hysterectomy at the outset. Furthermore, sufficient tests were not done to visualize the condition of the internal tissues before proceeding with the surgery. How the court drew that inference was sufficient details were not found in the medical record kept in the hospital relating to the surgery performed by the gynecologist. How bulky it was, whether only small fibroids are found in the uterus, and whether the fibroids were found in the uterus, and whether the fibroids were inside the uterus or outside. Court compared it with the details in the medical record of the urologist, which are more details were recorded. And this is where documentation is very, very important. We need to stress on this point also. And when you're trying to call a crisis consultant, be sure that what is being recorded. Here, the records of the urologist had given an evidence against the gynecologist. But then the gynecologist should have been prudent trying to write the proper things into the documentation. Having failed it, she should not have allowed the urologist to write in detail of all the things there in the document to go against it. But justice prevails when you are trying to not to follow your ethics in your medical practice. This is another case. All these cases had been handled by the state consumer commissions. This patient was admitted in the hospital, and the admitting doctor was a pulmonologist. He has advised the patient to be admitted in a hospital. Necessary investigations were advised and treatment was started by the hospital. On the same day when blood pressure of the patient increased, additional treatment was advised. A general surgeon was consulted for a different issue, stomach, abdominal pain, and X-ray sonography, which showed a thin layer of fluid in the Morrison spouse, conveyed an impression of paralytic ileus. On the fifth day, hospital abdominal distension was present. The patient was referred to a higher center where she remained hospitalized for 7 days and died thereafter. The allegation was that she was examined by an incompetent doctor, that to be a pulmonologist. It was further alleged that the patient was not treated for appendix. Unnecessary medicines was given which affected her kidney. The doctor's defense was, it was stated in defense that the patient was never admitted in the hospital with a complaint of appendix, and hence there was no need to treat or operate the appendix. This is absolutely not a proper defense because the diagnosis can get revised after review and evaluation. It was pointed that on the request of the relatives of the patient, a higher center where the treatment was given at the hospital was continued. The court rejected the allegation that the patient was treated by a pulmonologist, as the bed head ticket revealed that this doctor was only the admitting doctor and not the treating doctor. When you are an admitting doctor, make sure that the hospital puts you down as an admitting doctor, not as a visiting doctor, because quite often the receptionists who are trying to put down on the database of the hospital might put it in a different way. And sometimes an admitting doctor, if he becomes a visiting doctor or a visiting consultant in the records, record stands in the court of law, and things can go against you, like what has happened in this case, where the patient is supposed to have undergone an appendicectomy, which was delayed, went in for sepsis, and patient died. This is another case, a classical case of a consultant who does not have. We are having a bad habit of we don't take documents properly, and even if we go and try to work in a hospital, we don't get a proper appointment order, we don't get a MOU when you are a visiting consultant. The value of an MOU can be seen in this case. The clinic was owned and run by a non-medical person, wherein they did surgery for refractive errors. 3 years and 5 months later, the patient visited kind of pain, dryness, and burning in the eyes, and he advised him to use a 0.5 power spectacles. And why this patient did a surgery for his refractive error was he never wanted to use the spectacles, but then the surgery and then 0.5 power spectacles. The patient allegation was that the doctor advised guaranteed vision correction through LASIK surgery and freedom for wearing power glasses spectacles and forever. This is where I said the infrastructure, the co-consultants or whatever it is. This hospital, this clinic, this ophthalmology center has advised that you do a surgery for a refractive error, you don't need to wear spectacles. Is it really the fact? And if you are trying to work in a hospital of that, which is trying to go in the patient, giving a false hope, then you also land up in the court of law. Doctor's defense was, it was stated by the doctor that he was a visiting doctor of the clinic and used to visit the clinic once or twice in a month for performing surgeries only. His fees were directly paid by the owner of the clinic, and he never charged or collected the fees from the any patient, and he was never an employee of the clinic. He gets money from the clinic, but he's not an employee, he says. Where is the MOU to prove that it is not a status? No MOU. It was stated by the doctor that he had never represented, assured verbally or in writing at any point of time to any person, including the complainant, that after the LASIK surgery, you don't need to wear the glasses. Whether it was written in the consent form when he did the surgery, it is not there. Please see to that when you can't assure 100% correction of any of the surgeries, it has to be mentioned what is the percentage of the failure rate, and that too for a visiting consultant in an ophthalmology center, because ophthalmologist is one specialty which started the chain of hospitals in this country. It was stated that LASIK surgery is a cosmetic eye surgery. Many instructions and protocols must be followed after the surgery, and that even that some patients may require to wear low power glasses. And this need to be in the consent form, and a center cannot advertise saying that after surgery they don't need to wear spectacles. It was stated that the doctor always explained the surgery details to the patient, took their informed consent and provided copies of the case paper to them. So you can understand the value of a MOU with a place where you are going to be a visiting consultant. And when you are trying to do a surgery or trying to take a patient into the ICU, what is the scope, services, and whatever it is. The findings of the court in that case was the court dismissed the patient's complaint on the technical ground that it was late, barred from limitation. That is why we said 3 years and 5 months later, because it was for 2 years that the patient could have come and sued them in the consumer courts. But there are reasons where the patients can use a condonation of time without commenting on the merits of the case. This is a patient where I said from the code of medical ethics, which says don't try to chew and eat what you cannot digest. The patient was brought to the hospital at 11:30 a.m. who advised admission of the hospital and gave a letter to the patient's attendant. The doctor visits the patient at 12 p.m. and again at 2:15 p.m. The patient's condition deteriorated at around 6 p.m. The relatives requested another doctor who was taking rounds to see the patient, and that doctor also saw the patient. The primary referring doctor came at 9 p.m. The patient was critical, by that time. The doctor issued a death certificate for it. The patient's allegation was that the referring doctor did not render service, and the patient became critical and was therefore responsible for the patient's death. The doctor's defense: it was stated by the doctor that he was not the patient's doctor and treated the patient on humanitarian grounds, and the insistence of the relatives due to their inability to contact the doctor. The doctor who was there in the rounds did this job, and the court really appreciated the doctor for having taken care of a patient who was in an emergency. But what is the truth here? It was stated by the hospital that it provided only infrastructure and service to the doctors to admit and treat their patients, and was in no way concerned with the treatment of the patient. Understand that is where the MOU is very, very much needed. Even when you are a visiting consultant in the hospital, the MOU should have to say that in your absence, it is the duty of the hospital to take care of the patient, getting an instruction or an information from you, at least on the phone. Otherwise, the hospital can always say something like what they took as a defense from that side. Findings in the court: the doctor requested that the court found that the letter given to the patient by the doctor requesting admission also gave directions for investigation and treatment of the hospital, and the records of the hospitals also recorded that the admission was under the care of the doctor. The court appreciated the doctor, the consultant who was there in the rounds when the patient was sick. I think this is a very good example of how a consultant, a visiting consultant or a crisis consultant should have to behave in a hospital. This last case I am trying to show you is for this pandemic. It's no way related to this topic, but then I want to try to give a good thing to the attending doctors, because when we do a medical legal talk, we always try to tell the medical professionals, do this, do that, never try to venture that, do always these things. But then there is a law which is always there to defend this also. 17-year-old boy was brought with complaints of pain in the abdomen. All night, admitted in the hospital and the doctor. Investigations were done which showed platelet count of 25,000. Serology was dengue was done and was found to be normal. Due to dengue epidemic in the city, there was a delay in collecting blood and separating the platelets. Finally, the patient was transferred platelets. On 14/9, 48 hours later, the patient's condition suddenly deteriorated and he was shifted to the intensive care unit. Condition deteriorated and the patient passed away. The patient's allegation was it pointed to the blood reports dated 13/9/2004 from were of different values. It was alleged that after selecting the donors, there was a delay of few hours in collecting the blood and separating the platelets, which resulted in a delay in transfusing platelets to the patient, leading to death. This one statement was taken so well by the court, see the judgment later. It was alleged that the doctor managing the patient had a PMS degree and hence not qualified. This case was from Punjab. The judgment, the verdict has another statement for this also. It was pointed out that the blood bank was unlicensed as revealed by an RTI inquiry. It was alleged that only screening serology was done and not the confirmatory test. The doctor's defense was, it was stated that the different reporting of the two labs did not matter as the treatment remained to be the same, that is transfusion of platelets. It was stated that the doctor managing the patient or BAMS were not working, but were working under the supervision of a consultant, and BAMS doctors are allowed to work by the Punjab government. The court accepted all the defense put forth by the hospital. The court also took into account the fact that an epidemic of dengue was prevalent in the city at the relevant time, due to which there was a delay in transfusing platelets. Not all courts will have some sensible people sitting over there. They might look into the sympathetic situation. Here, as Rao Madam said, the court really took into the account how the hospital have worked into trying to recover a patient. And this is one bright side of the courts that every doctor should also see, to understand that courts cannot always be wrong as per their perception, but can always be unbiased. Let me come to the conclusion of what a visiting consultant or a crisis consultant should do based on my observations, which I have learned in the few years of experience that I have. A visiting consultant must have an MOU with the hospital or a clinic where he is, with its scope of services, time, date, and whatever it is. Be aware of the statutory license that the hospital have. Check the availability of the equipment. If you are going to be a gynecologist, try to see that what are the equipments available. An orthopedic surgeon, try to see what are the equipments available in the hospital and whether there is a standby CR machine is there. An NABH hospital will need to have a standby equipment which are to be used in emergencies. And your competent anesthetist, if you're an anesthetist, see to that if your boils is not working halfway through, how are you going to manage the boils without the boils being working perfectly? Few consultant competence should also be known in the place where you are visiting. Otherwise, there's no point in trying to go to a place where where somebody can't try to match your competence or cannot match the competence the patient requires. Know the crisis and render your service. If you are not competent to manage a urogynecological issue, never come into the crisis trying to help your own colleague or somebody, because along with the colleague, you will also be dragged to the court. If you are not dragged to the court, at least you can give a moral support to your colleagues. Call for your fellow senior service. Most of the time, we always fail not to take your senior services, because we think that the senior might comment about you, or if he's going to be a teacher, he might be commanding something against you. But then patient's life is more important. Morbidity or mortality of patient is going to land you in a court of law. Concerned if there is an intervention on the scope, and also on the consent should be there. Never enter the theater without getting a concern of the attendant standing outside. And see to that who is the attendant, who's been the next of the kin of the person who's lying there in the theater on the ICU. Get a copy of the document for your record. You always do a surgery or take care of the patient, leave the hospital, forget the whole issue. But years later, you might get a notice from a lawyer or from the court, and no document will be available, and the hospital might have changed hands. Today, you're buying a corporate hospital from one hand to another hand is often happens, and then document is missing. They always say we don't have the document. The previous team have taken the document. At that point of time, it will be a most difficult procession for you to defend in the court of law. Only a good document is going to defend you. No document is no defense for you in the court of law. And if you are handling a crisis patient, a troublesome patient, and you are called only for a day in a hospital, try to write to that hospital a letter on the speed post or a registered post and get the document relevant to the patient, a copy of the document, so that it is going to help you later if there is going to be trouble for you in the court of law. Never take for granted your competence in a critical care. That is where you need to call the seniors. That is where you have to call your teachers. Communicate with the patient or attenders about your services. What is the service you are going to do? Apply trauma, you are going to be only a vascular surgeon. Say what is the role you are going to do, and for that you try to get a consent and try to get clear information to them. Today, the days of video consult is there. Try to do that also if it is possible. Get your payment on the record. Never enter your services free of charges to any of the hospital who are trying to call in a crisis. And this payment, if it is the best way to get it is by a voucher, not by a NEFT transfer or by a check. It is ideal to get a voucher there at that point of time, because transaction of consideration is the one which is going to put you in the court of law. You might have done your services free of charge. When you land up in a crisis, you may not be paid. 50% of the time, you will not be paid for the services, because the survival of the patient will be at a question mark. Morbidity and mortality is going to be there. And no patient is going to pay the hospital in total when things go against them or against their family. At that point of time, it is better you take the fee of the day when you leave the hospital. Otherwise, you might even lose the fee, and it is not worth when you are trying to support a hospital in a crisis, losing your fee also. I think I have covered what is needed for a visiting consultant, both from the income tax angle as well as the revenue angle, and try to defend themselves in the court of law, and never be too defensive at occasions. There are times when you need to take a little bit of risk, but when you are taking the risk, be sure about your competence to handle the case, and then try to do things in the right, perfect way within the legal and ethical framework. Thank you for such an opportunity given. I'm really fascinated how Ashok Shukla could find topics. And really thank you very much, sir, for giving me a day to prepare this talk so that I can deliver it elsewhere also. Thank you very much. Good luck. Thank you all.
Sir. Thank you. And I appreciate, sir. I just spoke to you around 3 to 4 days before only on this talk, and you have done such an excellent presentation with all the aspects covering. And I think so, sir, it is very important topic because a lot of time, after listening the whole, seeing the whole PPT presentation of your talk, doctors would have realized at what levels issues could have occurred and can have occurred. And as people display the rights and duties, I think so your conclusion slide should be in hand of all the visiting doctors, because these are all the points. If they take care, they will never land up in the problem, or the chances would be lowest, and even if they land up, they can come out easily. Otherwise, sometimes major issues are land up just because they have not followed those guidelines, because the patient was seen on an emergency basis. They just went, it's a friend's hospital, and then when the patient complains, then everybody starts taking the hands off that I never took charge, it was a emergency visit, there is no documentation. The other person feels, I thought he will document. This person feels the hospital belongs to him, he will document. So a lot of other things happen, sir. Excellent talk. I appreciate in a very short term. I think so in future webinars, again, we will keep with some interesting cases for 2 hours or 3 hours only on this topic of different aspects of the visiting. Thank you, sir.
I will also try to stress back again the code of medical ethics to be read. Everybody on the
yes, I still remember.
I think whatever topic you bring, the code of ethics is there for them.
Yeah, that was a really golden line, sir. On every birthday, the doctor should read the medical ethics, or every 1st January he should read. He should fix up, and if he read and follow the medical ethics, I don't think so he will be any time in any court of law because of any problem. As we are running short of time, we'll immediately go to the last topic of today, which is again a very important talk, where arrest of doctor and the issues, the Supreme Court guidelines, bail, because a lot of time people feel ki why the bail was not given, or why immediately bail doctor should have got, why he was arrested. So arrest of doctor and bail, and we have an excellent speaker, Dr. Vidya H. Shetty. She's MBBS, DGO, DPH. She's a law graduate, MBA, postgraduate diploma in hospital administration. She is also a diploma in gynec endoscopic surgeon. She is practicing as obstetrician gynecologist from last 18 to 20 years, attached to Sai Leela Hospital, Bhiwandi. She is also certified by Government of India, medico legal consultant and trainer, and medical officer of health in BNCMC. So over to Dr. Vidya Shetty, madam.
Thank you so much. So good evening, everyone. We've had a very long afternoon. I know abhi tak bahut exhaustion level aa gaya hai, but I will try to go through it fast. But I think this is a very important topic because all of us are already very phobic of, the Supreme Court and going to the various courts and the disputes and the consumer courts. So these are certain highlights that I have given. I think I've made the presentation in a very positive format. I hope it brings us into a very positive frame of mind. So first thing that is important to all of us is that we need to simply understand that a lack of care or an error of judgment or even if it is fatal, if it does not constitute to medical negligence, a culpable medical negligence, like many of us feel कि कुछ भी छोटा भी हो गया तो we will have to go to court and where there will be a lot of complications. The court is not looking at us to find our faults. So it is very, very important that if we are able to give our services in the right frame, in the right way, and the required minimum at least, then the doctor will not be held liable for any kind of negligence. The professionals may certainly be held for negligence, that is when they do not have the requisite skills which they claim that they have. Like if they are committing that they can do a surgery, they should do the surgery to a certain level. And if they have the skills, but still they do not exercise it or do not perform a certain kind of procedure to a certain level of the skills that they possess already, then this would be a case where it could be held as a negligence. So very important for us is when we are looking at the Supreme Court judgments, the Supreme Court judgments very clearly mentions that the negligence has to be gross. The word gross is not used in the section 304A of the IPC, but as so far as professionals are concerned, it is to be read. All of us have to understand that the court insists on proof of gross negligence to find a doctor guilty. So the maxim which we always see is res per loquitur, where we feel that the event will speak for itself. No other evidence is required. But this evidence would work only in the civil court and not in the criminal court. So friends, we need to just highlight, many times we feel that not having knowledge of law is okay, but actually it is not. You don't have the knowledge of law doesn't make you safe from all the legal implications that would come. So all of us to know the basic law when we are practicing and the things that we would come across day in and day out. So the Supreme Court states that statutory rules or executive instructions should be incorporating indefinite guidelines governing the prosecution of doctors. This needs to be framed by the state and central government in consultation with the Medical Council of India. And until it is done, the private complaints must be accompanied by credible opinions from other competent doctors. So they really respect the medical knowledge and say that until and unless a doctor does not say that this is rashness or this is negligence, it cannot be taken in a criminal court. So doctors accused of rashness and negligence may not be arrested simply. They can be arrested only on grounds when the arrest is important for the investigation, the arrest is important for collecting evidence, or if the investigating officer fears that this doctor will abscond and will not come for the further hearing. So these are the only cases where they can arrest a doctor. But the Supreme Court doesn't say that doctors cannot be prosecuted for medical negligence. They can, but it has emphasized that the need for care and caution in prosecuting the doctors is in the interest of the society. It cannot be done just like that. It cannot be done for small things like, a lack of certain things, or you have forgotten, to do a certain, small thing, or misjudgment, because many times what management you have decided would not have been a management which your senior would have decided or a co-doctor would have decided. That doesn't mean that what you have decided has been of a lower quality, and that's why you can be, dragged to court. So the Indian Supreme Court has ruled that doctors may be criminally prosecuted only for gross negligence or a high degree of negligence. So very important when we are looking at criminal court for all of us to know gross negligence is absolutely required. It is not an error of judgment or lack of care that would cause a criminal case to be, against any of the doctors. So, but all the cases in the Supreme Court are usually based on these 3-4 major landmark cases that we have seen. So one is Dr. Suresh Gupta versus Government of NCT of Delhi. We'll go through this. I have quoted them in a number of places. Jacob Matthews in State of Punjab, Kusum Sharma versus others versus Batra Hospital, and Martin D'Souza versus Muhammad Ashfaq. Holding a doctor criminally liable in negligence for his professional acts. For fixing criminal liability on a doctor or a surgeon, a standard of negligence is required, which I've been saying from the first slide, that a gross negligence or recklessness. So a doctor cannot be held criminally responsible for patient's death unless his negligence or incompetence shown in disregard of life or safety of the patient and mount to a crime against the state. So it is that if he does not feel for the patient, he's totally apathic and has done it because he just doesn't care. That is only gross negligence. When you are already trying to save your patient and still you can't save, that would not mount to gross negligence at all. When a patient agrees for a medical treatment or surgical operation, every careless act of a medical man cannot be termed as criminal. This is mentioned in the Supreme Court judgment. So I have mentioned medical man, it can be a medical woman as well. It can be termed criminal only when the medical man exhibits a gross lack of competence or inaction. So mere some kind of inadequacy in the care or caution, it can create a civil liability, but it is not enough to create a criminal liability. So the approach of the courts in the matter of fixing criminal liability on the doctors in the course of medical treatment is necessary so that the hazards of medical men in medical profession being exposed to civil liability. When it is a civil liability, it would be some kind of a compensation. But when it comes to criminal liability, it could be arrest, imprisonment. The doctor would be in a mental stress to get bail, and maybe bail would not be even possible. So that is the reason the court has kept a little bit of a emotional ground that criminal prosecution of doctors without adequate medical opinion, painting to their guilt, it would be a great disservice to the community at large and would lead to shaking the mutual confidence between the doctor and the patient. To convict a doctor, the prosecution has to come out with a case of high degree of negligence on the part of the doctor. The courts have therefore always insisted in the case of alleged criminal offense against doctors causing death of his patient during treatment, those complain that doctors show negligence or rashness to such a degree as to indicate mental state which can be described as total apathetic towards the patient. So such gross negligence alone is punishable. No doubt, to fasten the criminal liability on the doctor or surgeon, the degree of negligence has to be proved to be very high. So the lordships have described as gross negligence or recklessness. It cannot be attracted to a doctor's professional acts while treating a patient. So during the course of trying to save your patient or giving the patient necessary care, attention and skill, if you land up in some complication, it would not be a gross, it could go to the civil court, but not go to the extent of arrest, criminal court or bail. So the last three deficiencies definitely will attract civil or negligence. Criminal prosecution of doctors without adequate medical opinion would be doing great disservice to the community, which we have already disservice to the community, because in case something like that happens, the doctor and the hospital will stop focusing on giving best service to patients. They would be more defensive and be taking care that they don't land up in some kind of unnecessary discrepancy, negligency, medico-legal concept. So that is the reason they keep their safety profile. So that is the reason the Supreme Court has given this verdict. So their lordships therefore have treated availability of medical opinion in support of the prosecution in the first instance to be signed on. This is mandatory. Without having an opinion from a doctor regarding the rashness or the negligence, there can be no criminal prosecution of any medical consultant. The case of doctors, that is surgeons and physicians, being subjected to criminal prosecution are on the increase. The investigating officer and the private complainant not always have a knowledge of medical science, so as to determine whether the act of the medical professional mounts to rash or negligent act within the domain of the criminal, that is section 304A of IPC. The criminal process, once initiated, subjects the medical professional to serious embarrassment and sometimes harassment. He has to seek bail to escape arrest, which may or may not be granted to him. At the end, he may be exonerated by acquittal or discharge. But the loss which he has suffered to his profession, to his reputation, cannot be compensated by any standards. So a private complaint may not be entertained until and unless the complainant has produced prima facie evidence about the court in the form of credible opinion given by another competent doctor to support the charge of rashness or negligence on the part of the accused doctor. Investigating officer, before proceeding against a doctor regarding a charge of accused rash or negligent act of omission, he has to have an opinion from a doctor. If the complainant is, if the action is being taken by the police because of an FIR being filed, then in that case, a doctor in the government service in the same branch of medical practice is mandatory, without which a criminal case cannot be filed. A doctor accused of rashness or negligence may not be arrested in a routine manner. I just said they can be arrested only for collecting evidence, or if he feels that the doctor would not come or would just abscond, and that is the only thing, or if he feels his investigation is going to be tampered. That are the only condition he can do it, but it cannot be done in a routine manner. So the investigating officer has to take a doctor's opinion or at least a medical team, if there is a medical team which is there. So a private complaint or even an FIR based on a non-medical layman's vantage, however categorical or systematic, would not entitle the magistrate to proceed with a complaint against a doctor for criminal negligence relating to the professional acts. There is this case, which is Kusum Sharma and others versus Batra Hospital. Here, the Honorable Supreme Court has put forth certain principles. So on the scrutiny of the leading cases of medical negligence, both in our country and other countries, that is UK, some basic principles emerge in dealing with the cases of medical negligence while deciding whether the medical professional is guilty of medical negligence. Following well-known principles have to be kept in mind. One is negligence, that is breach of duty exertion by omission, to do something which any reasonable person would have done and the conduct of human affairs would do. So it is only behaving in a reasonable manner and giving your patient reasonable service. So negligence is a very essential ingredient of an offense, and it can be established by prosecution, must be culpable or gross, and not the negligence merely based on error of judgment. It is not based on the error of judgment. So the medical professional is expected to bring a reasonable degree of skills. Utture sir had mentioned the Boehm's law. So it's very clear, you don't have to be exceptionally good. You can just do what you're supposed to do, at least at the basic level, not below that. So the care that you give doesn't have to be a very eccentric level of care, but it cannot be a level of care which is even below the average. So an average level of care, the average management of the patient is absolutely mandatory. In the realm of diagnosis and treatment, there is a scope for genuine difference of opinion. Each person has a different way of dealing with patients. Each person has a different view of thought, and they have their different schools of thought and the way they would like to manage. So all of it is respected. And just because you manage a patient in a different way doesn't become that you are wrong. So everybody has the choice of adapting the procedure. Number of times we adapt a little higher, a procedure with a higher element of risk, but that is for the betterment of the patient, thinking that if we keep, try to do a procedure with a lower risk, maybe the outcome will not be that good. So in that case also, it will not come to a gross negligence, nor would it be a criminal offense. So just because a professional looking of the gravity of the illness has taken a higher element of risk to reduce out of his suffering, which did not get the desired result, it does not amount to negligence. Negligence cannot be attributed to a doctor so long as he performs his duties with reasonable skill and competence, and it would not be conducive to the efficiency of the medical profession if the doctor could not administer medicine without a halter around his neck. That is what we all are going through right now. Every case that we do, we have a halter around our neck and we don't know what's going to happen. It is a bounden duty and obligation of the civil society to ensure that the medical professionals are not unnecessarily harassed and humiliated, so that they can perform their professional duties without any fear and apprehension. The medical practitioners at times also have to be safe from such class of complainants. All of us know about this, that these are the different kind of pressure tactics for the hospitals and the doctors, and it is just, you know, malicious proceedings and all kind of mental torture so that the doctor gives up some amount and the things get closed there. So medical professionals are entitled to get protection so long as they perform their duty with reasonable skills and competence and in the interest of the patients. The interest and welfare of the patients are of the paramount for the medical professionals. No doctor would like to harm his patient, come what may. So in our considered view, the forementioned principles must be kept in view while deciding the cases of medical negligence. We should not be understood to have held that doctors can never be prosecuted for medical negligence. As long as doctors have performed their duties and exercised an ordinary degree of professional skill and competence, they cannot be held guilty of medical negligence. It is imperative that doctors must be able to perform their professional duties with a free mind. The Supreme Court bench, now this is a case which is going on in 2018. This is Deepa Sanjeev Pavaskar and others. Both husband and wife are gynecologists. They had a patient with early pregnancy and she had fever. She went to the hospital. They were not there, consulted on telephone. And then the patient went bad. The patient was transferred. The patient expired. The postmortem showed that there was pulmonary embolism. They were not granted bail. So this is the Supreme Court bench comprising Justice Abhay Manohar Sapre and Justice Uday Umesh Lalit, and they granted them relief from arrest under Section 304A of the IPC for criminal negligence. The Supreme Court order read as follows: both the petitioners, namely Deepa Sanjeev Pavaskar and Sanjeev Anand Pavaskar, shall not be arrested in connection with the crime 71 of 2018 registered by the Ratnagiri City Station. The bench further directed that both the petitioners shall cooperate in the ongoing investigation in connection with the offense in question and will make themselves available as and when required by the investigating officer. So also in 2018, June, there was a verdict which said that no FIRs against doctors. So physician cannot assure that the patient will fully recover in every case. A surgeon, when he does the surgery, he would give 100%, but that doesn't mean every patient would be treated 100%. So what does a person approaching the professional, what can he expect? He can expect that he gets the best out of that professional. So in Jacob Matthew case versus State of Punjab, the court laid down the standard of be applied to the judging to determine whether the person charged has been negligent or not. He has to be judged like an ordinary, competent person exercising ordinary skill in that profession. It is not necessary for every professional to possess the highest level of expertise in that branch which he practices. Parmanand Katara versus Union of India. These are a few cases which are important to us. If we just go through, I have made it very short so that we don't take much time. The Supreme Court referred to the Code of Medical Ethics drawn up by the approval. In Parmanand Katara, there was a case, it was on Hindustan Times, where a person was found on the road with a scooter accident and nobody were willing to take the patient because it was a road traffic accident. So this was the statement after that, where the medical ethics drawn up with the approval of the central government under Section 33 of the Indian Council Medical Act and observed every doctor, whether at a government hospital or otherwise, has the professional obligation to extend his services for protecting life. The obligation being total, absolute, paramount, laws of procedure, whether in statutes or otherwise, should not be sustained and therefore must give way. So very important is the doctor, it's the duty of the doctor in an emergency to begin treatment of the patient, and he should not wait for the arrival of the police or wait for legal formalities, whereby delaying the patient's prognosis and also the treatment of the patient. So life of the person is more important than legal formalities in view in accordance with the Hippocratic oath of doctors. Now, though this decision is put, that is a duty of the doctor to attend to a patient who is brought to him in emergency, it does not state what would be the penalty of a doctor who refuses to attend the said patient. So Paschim Bengal, Khet Mazduri and others versus the state of West Bengal. In the Supreme Court held that denial of emergency aid to a petitioner due to non-availability of bed in government hospital amounts to violation of right to life under section Article 3021 of the Constitution. So the court went on to say that constitutional obligation imposed on the state by Article 21 cannot be abdicated on the ground of financial constraint. So it's absolutely mandatory. Mohammad Sulaiman versus Shankar Bhandari. The respondent suffered a fracture on his hand, went to appellant who called himself a qualified medical practitioner. The appellant bandaged the respondent's hand, prescribed certain medicines. He was ultimately taken to another doctor. By the time the damage was already done, it was found that the appellant was not a qualified doctor to give the treatment to the respondent. So the Supreme Court has directed them to pay a compensation of 80,000 rupees. Surendra Chavan versus State of MP. The appellant was having a degree of Bachelor of Medicine in Electro-Homeopathy from the Board of Electro-Homeopathy. This is not a medical qualification in the Indian Medical Council Act 1956. Yet he performed an operation to terminate a 3-month pregnancy and the patient died due to shock due to non-application of anesthesia. The Supreme Court confirmed the sentence, reduced his rigorous 1.5-year rigorous imprisonment under section 314-341 and a fine of 25,000 payable to the mother of the deceased. State of Haryana and others versus Raj. It was held that if a child is born to a woman even after she had undergone sterilization, I think many of us gynecologists have with us always. So I was very happy when I saw this. So I mentioned this in the presentation. The doctor was not liable because there cannot be 100% certainty that no child will be born after a sterilization operation. The court followed the earlier view of another 3-judge bench in the state of Punjab versus Shivram. This decision be deemed to have overruled the 2-judge bench decision in the state of Haryana and others, in which it is held that if a child is born after sterilization operation, the surgeon will be liable for negligence. PM Rao versus Jai Prakashu. This was a case of a young guy who was scoring very well, 100% marks, 93%, offered a BE degree course in 4 engineering college, had a nasal discharge, required a surgery, tonsillectomy was done. Post tonsillectomy, he did not regain his consciousness for 3 days. And then after that, after 15 days, he couldn't speak and he had lost his memory. And then his father took him to Lord, to a professor of neurosurgery. It was found that there was cerebral anoxia, which related an improper intent of anesthetics and failure to take immediate steps to reduce the anesthesia. The court, after examining, including the professor of anesthesiology, held that defendants were clearly negligent in discharging their duties and the state government was vicariously liable. Dr. Lakshman Balkrishna Joshi versus Trimbak Bapu Godbole. Patient had suffered fracture of femur. Accused doctor, while putting the leg in the plaster, used manual traction and excessive force for this purpose with the help of 3 men. Although such traction is never done under morphia alone, but this was done without this has to be done under proper general anesthesia. This gave tremendous shock, causing the death of the boy. On these facts, the Supreme Court held that the doctor was liable to pay damages to the parents of the boy. Suresh Gupta versus Government of NCT of Delhi and another is one of the most important mark cases. Here, the appellant was a doctor accused of 304A IPC for the death of the patient. Operation was performed was removing a nasal deformity. The magistrate who charged the appellant stated in his judgment that the appellant was conducting the operation for removal of the deformity, gave a wrong incision, and due to which the blood had seeped into the respiratory passage, and because of the patient collapsed and died. The High Court upheld this order of the magistrate and observing the adequate care was not taken for seepage of blood leading to asphyxia. The Supreme Court held that the medical opinions adduced by the prosecution, the cause of death stated was not introducing a cuffed endotracheal tube to the proper size as to prevent aspiration of blood from the wound in the respiratory passage. So from the medical opinions produced by the prosecution, the cause of death is stated to be non-introducing a cuffed endotracheal tube of proper size as to prevent aspiration of blood from the wound in the respiratory passage. This act attributed to the doctor, even if accepted to be true, can be described as negligent act as there was lack of due care and precaution. For this act, negligence may be liable in tort, but his carelessness or want of due attention and skill cannot be described to be so reckless or grossly negligent as to make him criminally liable. A.S. Mittal and others versus State of UP. In a free eye camp organized for ophthalmic surgical treatment of patients. However, the eyes of several patients during the operation were irreversibly damaged due to post-operative infection of the intraocular cavities caused by normal used in the time of surgery. The Supreme Court directed the state government to pay 12,500 as compensation to each victim, as there was clear negligence. This is Malhotra versus Kriplani. The division bench of the court has passed some direction which reads as under. We therefore direct that whenever a complaint is received against a doctor or hospital by a consumer forum, maybe district, state or national, or by a complaint was made by the consumer forum, the criminal court should first refer the matter to a competent doctor or committee of doctors specialized in the field relating to which medical negligence is attributed, and only after that, after the doctor's committee reports, then there is prima facie case of medical negligence should the notice be then issued to the concerned doctor or hospital. It is necessary to avoid harassment to doctors who may not be ultimately found to be negligent. We further warn the police officials not to arrest or harass doctors unless the facts clearly come within the parameters laid down in the Jacob Matthews case. Otherwise, the policemen will themselves have to face legal action. Thank you so much for a very patient hearing, and that too being the last section. Thank you to all the seniors. It was a wonderful experience, learning so much from all of you. And Dr. Ashok Shukla sir, thank you so much for this opportunity. Thank you.
Yeah. Thank you, Dr. Vidya, for an excellent talk, in depth, in detail. The only reason of getting this talk was because a lot of time whenever a problem occurs or complication occurs, the doctor knows that patient is going to go to the consumer court, but doctor is more worried that I should not get arrested, because the doctor starts feeling that abhi ho gaya hai, abhi patient letter dekhe gaya, abhi police mein dalega and I will get arrested, because the name what the doctor creates, it takes long time. But if he suddenly gets arrested and the media hypes, so then becomes a big issue. And that is the reason of this topic is the court has come always to protect doctor. The court doesn't allow doctor to be arrested primarily in the beginning. It has to be proved in the court of law that has been an gross negligence or error before coming in. A mens rea or guilt mind has to prove, which is not easy. So doctor should not be worried if they have whatever the protocol is, whatever the pro forma is, whatever the schedule of the court is, that will follow. Nobody will come immediately and arrest you.
Provided they have done their best.
Yes. And nobody will come immediately and arrest. And that has to be proved in the court of law. So they should not feel that now today complication occurred, or tomorrow I might, because I have seen a lot of doctors going in depression, leaving practice before the verdict has come or before the case goes to the court. They themselves go in depression. If doctor goes in depression, the whole family goes in depression. And also the next patient who is going to come for treatment is going to suffer, because this doctor is not mentally fit now. He is under the pressure of a court case going on, which would be immense. So thank you, madam, for a detailed presentation. I think so we are running short of time, but we'll see whether we can take some questions. Dr. Dinesh Thakre sir, over to you. If there are specific, we'll take. Otherwise, yeah, maybe in 3-4.
Yeah, it's already 5:30. I think only important question I will take 2 or 3.
Yes.
This answer is known by many of us, that what is the limitation period for filing a complaint? Still someone want to answer in short? What is the limitation period for filing a complaint? Dr. Ravi Shankar?
I think so. Dr. Utture sir has come from me. Sir, they wanted basically the limitation time for the MMC, whether anything specific. Dr. Utture sir.
No, as far as MMC is concerned, there is no limitation period. And even as far as consumer protection is concerned, see, remember, the limitation period can be from the time where that patient comes to know that he has got the problems. Remember that. It is not supposed to be from the actual this. I think Madam Rao will be able to tell you much better about this, because there have been cases of pediatrics where the cases have been filed when he has become either a teenager or an adult, because there was some problem during his birth. So limitations, we cannot really go, otherwise it's supposed to be just for 2 years. So I think she'll be able to tell you better than what I will be able to tell you. But as far as MMC is concerned, there is no limitations. But the only thing that may protect you is that as per our MCA Act, your indoor papers and all are supposed to be, kept for 3 years.
3 years.
So you can claim in future. That is, if the patient has not already got the Xerox copies of the endo paper, you can claim in future that you have not got those papers. But sometimes that may act against you also. If the patient has got the papers and you have not kept the papers. So that is as far as MMC is concerned.
Yeah, Rajalakshmi Rao madam, you wanted to add, honorable madam.
Right, 2 years is limitation. Ideally, it will not be extended. Limitation will not be extended in the consumer courts unless you say he went into coma and came out of coma, or he was hospitalized, or you have to give real reasons for them to extend it. Now it's going to be even more difficult because the act has become very tight, unlike before. So I think you have to stick to 2 years.
Thank you, madam.
Madam, how much that defense is taken that the time has to be calculated from when the patient has come to know that there was a deficiency or
yes, from the time the person has come to know of it, but he has to give it proper evidence. All this has to come with proper paperwork. See, everything you file and keep, whatever your documents are, you keep it on record. That is a must from your point of view, because a lot of fudging records are happening, and the patient can really file it against you and show that you have fudged it later on. You'll be in deep trouble.
Next question is for Dr. Utture, sir. If the doctor, after being summoned by the council, is unable to attend, can he seek a postponement? And if so, how many times?
Yeah, as far as the act is concerned, nothing in detail has been said about that. But we have made it a policy that we allow one adjournment by the RMP and one adjournment by the complainant. Beyond that, we don't allow adjournment. Of course, unless there is they can prove that they really cannot attend. He is bedridden or he's undergone some surgery or something like that. So then he has to give evidence of all those things. Then we may allow him the second adjournment. But normally we allow only one adjournment as far as MMC is concerned. Otherwise, we will rely on whatever answers and papers he has submitted to the MMC.
Right, sir. Thank you. Dr. Ravi Shankar, sir, are you there? So there is a question for you. What type of MOU to be signed for the visiting consultant? Just guidelines.
I think only a legal expert will be able to do the contract. It's a contract. See, whatever your service you're going to provide, whatever infrastructure that is there, what's your time, date, what's your fee structure, how to get the fee, what the payment of fees, and all these things, that is all administrative. As far as professional, you are a surgeon. You can only say the scope of your surgery, to what extent you will be able to do, what is it you can do it. That is your competence. You can put it down in the MOU and get it done. It's on the payment and the availability of the colleagues, getting services of the ICU consultants, getting the services of the hospital staff. These are all have to be done in the MOU. It has to say that in your absence, it is the responsibility of the hospital to take care of the patient alive. Taking care of the patient in crisis. If there is going to be a crisis, you just can't say that their consultant has not been on the phone. He is not available to give us instructions. That cannot be the answer from a hospital. Most of the hospitals will do that if you don't have an MOU and if you are only an admitting doctor and you are not a consultant. This is the time when everybody wants to shut off the responsibility when there is an emergency. And that MOU will see to that the hospital take care. Because when you are a visiting consultant, you can't be at the bedside for 24 hours. Other than your presence, it is the duty of the hospital to take care of the patient. And we can't escape that responsibility. That has to be really put down in the MOU. That's why. If you don't have an MOU, you can always come to the court and say that it is the duty of the consultant to take care of the patient. You don't have an MOU with them, saying that we are supposed to take care of the patient in his absence. But morally, they can't talk. But legally, they can talk.
Yeah. Right, sir. Thank you. Probably now this is the last question.
Last question.
That what should a RMP do when called to see a dead body? Now we have taken 2 lectures on this, and the one line answer would be that when you don't know the cause of death, don't issue the medical certificate of cause of death. You can issue the declaration of death, and you can then you can call police if you want any, if you feel that there is any foul play, but don't issue the cause of death certificate unless and until you know the cause of death really. So over to Dr. Shukla.
Thank you. Yeah, as already sir told, there were two big programs. I think so 2 hours each on death in the OPD scenario and death in IPD, in indoor hospital scenario, where in details we have done. So I thank Dr. Pankaj Bhandarkar sir is there. Dr. Pankaj Bhandarkar sir. No, then I will take the honors of doing the Thanksgiving at the end. So at the as the IMA Medico Legal Cell Chairperson, Dr. Ashok Shukla, on behalf of IMA Maharashtra State, I would like to thank all the speakers today. They have done excellent, with an excellent talk, especially regards and obligation, and thanks to Honorable Rajlakshmi Rao Madam, who not only gave an excellent talk, but she attended maximum part of the webinar to see exactly how doctors are trying to help themselves or trying to increase their knowledge and aware, so that we can do best for our patients also, because what better care and best care, what the court wants, we are learning, and we are trying to tell the doctors that the court also expects this is the highest standard care what you have to do, so that they can do the best. Also how to protect our colleagues, because they should not land up in a wrong issues where there is not much mistakes from them. As you told, a lot of forging is happened, sometimes patients unnecessary has malified interest and starts harassing. So that also, so thank you Rajlakshmi, Honorable Rajlakshmi Rao Madam, special thanks for you. Yeah,
Can I just have one line?
Yeah, please, madam.
That I'm sure you all touched upon, and I mean, of course, I did say that you must have all your paperwork in order, but very important thing is the discharge summary.
Yes.
That is very crucial for any treatment. You make sure that particular one has all the details, whatever it is. That has to show what the patient should do after being discharged, so that post-operative treatment and those issues you will not be pulled up if you have given proper guidance. Very important.
Thank you, madam. It's very important, because a lot of time I remember one of our medical legal speaker telling that discharge card is like a mirror of the hospital. It basically reflects how good the treatment was here, because the properly mentioned in detail discharge card tells how much the hospital cares for the patient, not only in the hospital but also wherever the patient goes that discharge, with that discharge card, the other doctor knows exactly what has happened, and so that can give better treatment if there is an emergency. Then special thanks to Dr. Shikumar Utture sir, Maharashtra Medical Council President, also was a speaker today, always supported me throughout all my webinar series. This was the 17th webinar series, the last of this academic year of IMA Maharashtra State, that is 1920, under the leadership of Dr. Avinash Bondwe sir. Dr. Ravi Shankar sir, National President, who has always, over a shorter period, never told me no. Whenever I have asked for a talk or topic, he's always there, came with excellent reviews, with good amount of judgments. So special thanks to you, sir. My other speakers, Dr. Shilpa Pawar, Dr. Vidya Patil, for an excellent talk today. Special acknowledgement to Dr. Santosh Kakade sir, the member State Consumer Forum, Maharashtra State, for attending and also guiding in most of the webinar series wherever appropriate platform required was. My Dr. Dinesh Thakre sir, my co-moderator, who's always stood with me from the first program till the last, my co-chairperson, Dr. Rajkumar Shurivanshi, then IMS stalwart leaders from outside Maharashtra also, Dr. Shiva Kumar from Dharwad, Karnataka, always there with us, telling us and helping us and guiding us also. He also delivered during this webinar series 2 excellent talks. Then today, Vice President from Haryana Medical Council also joined. Sir, he's there, sir is there. Which was, again, I would like to put on record acknowledgement. So thanks each and every IMA leader, national and
Dr.
state.
Dilip Kumar Acharya from Indore is also there.
Yeah, Dr. Dilip Kumar Acharya, I think so, he's there on the screen also. We can thank you for attending and motivating and boosting, because this helps us to do better and better and hunt for more and more. The whole medical legal team, Dr. Padma Iyer, there's a huge list. Then the IMA Mira Bhainder branch, Dr. Sanjay Mehra, Secretary, Dr. Vivek Dwivedi, for giving us a platform and standing with us throughout the program, and all my attendees, because all our webinars had attendance from 200 to 2000, and this was because of them having faith on us and giving us an opportunity to come out with newer and newer webinar series. Friends, we will still continue. The next week is the only week which we have given a break. Otherwise, all Fridays were mine. There was no Friday given. But next Friday, Saturday, Sunday is Maharashtra State Conference of MasterCon. So I would request everybody to enroll for MasterCon and do attend on the digital platform. It's 6 MMC points program. And after that, again, we'll be back with the programs and having more amount of case discussions also, as Dr. Avinash Bundwe sir has today already mentioned. So thank you, sir. Thank you. Have a nice day. And also my technical partner, DigiShield, who are there for all the programs, supporting and giving us, maintaining this digital platform, attendance sheet, and giving us this platform. So DigiShield, thank you. Thank you, Dipen. So thank you, I am Maharashtra State, and thank you, everybody. Have a nice day.